Deputy Chief Justice and members of the
Securities USA LLC.
On behalf of the Competition Commission, on behalf, together with Ms. Hop, Ms. Zikalala, Ms. Drake, Mr. Ngumalo, and Mr. Monareng, we are instructed by Nzabanzaba attorneys.
Deputy Chief Justice, Justice of the Court, I appear on behalf of the 1st, 20th and 21st respondents, which are referred to collectively as the Bank of America respondents. And I appear together with my learned friends, Mr. Nkongo and Mr. Mbakiwa, and we're instructed by Weber Wenzel. And just to make it clear, that's in case number 30/2024, the Commission's application for leave to appeal.
Deputy Chief Justice, I appear for the second respondent, BNP Paribas, together with my learned friend, Mr. Mohammed.
Thank you, Mr. Campbell.
Deputy Chief Justice, Justices of the Court, I appear on behalf of the third and fourth respondents. Mr. van der Nest, who is leading me and is on the heads, is not here today. I'm on my own.
Thanks a lot.
May it please the Court, I appear on behalf of the fifth respondent with my learned junior, Ms. Maharaj Pillay, instructed by CDH Legal.
Thank you, Mr. Loxton.
Deputy Chief Justice, members of the Court, I appear with my learned friend, Mr. Mokoena, for the eighth respondent, Standard Bank of America, in the Commission's application for leave to appeal, and we do so on the instructions of Herbert Smith Freehills.
Thank you very much.
Deputy Chief Justice, Justices, I appear on behalf of the ninth respondent, Numera. Mr. Butler, who is leading me, is not in court today, instructed by MGI Competition Law.
Thank you.
Good morning, Chief Justice, Justices. I appear for Commerzbank, the 12th respondent, with Ms. Williams, instructed by Weber Wenzel. Thank you.
Thank you.
Deputy Chief Justice, members of the Court, I appear for the 13th respondent, Macquarie Bank Limited, together with my learned friend, Ms. Bosman, instructed by Bowman Gilfillan.
Thank you.
May it please the Court, Deputy Chief Justice, I appear for the 14th respondent and also the 19th respondent, together with my learned friend, Ms. Abidon.
Thank you. Well, I don't think that completes the lineup, unless you want to tell us something else.
Deputy Chief Justice and Justices of the Court, I appear for the 25th respondent, the Nedbank Bank. I appear with my learned junior, Tsakani Maralen, on the instructions of Worksman's attorneys. And I apologize if I've jumped the queue.
Thank you.
Deputy Chief Justice, Justices, I appear on behalf of the 27th respondent, First Rand Bank, together with my learned friends Ms. Muvangwa and Ms. Machlangu, on the instructions of Cliff Decker Hoffmeyer.
Thank you.
Deputy Chief Justice, Justices of the Court, I appear on behalf of the 28th respondent, Standard Americas Incorporated, on the instructions of Herbert Smith Freehills, together with my learned junior, Mr. Mokoena.
Thank you very much.
Deputy Chief Justice and Justices of the Court, I appear with Mr. Marriott and Ms. Nyembe for the 23rd respondent, Credit Suisse Securities USA, in the appeal under case number 27 of 24.
Thank you very much. That seems to be it. Mr. Ngukaitobi, you are aware of the uninterrupted time you have to make your submissions. We will just disturb that when we break for the obligatory breaks for tea and lunch. But other than that, please go ahead.
Thank you, Deputy Chief Justice. What we propose to do is to address 8 topics. The first one is the conduct that we submit amounts to a single overarching infringement or conspiracy. The second is the attribution of that conduct to the named respondents. The third one is the jurisdiction of the Competition Tribunal over what has been referred to as the Pio Peregrini, who were part of the alleged conspiracy. The fourth is the admissibility and the probative value of economic evidence in cartel prosecutions. The fifth is the issue of authority to respond specifically to the 3 banks that say that we did not plead enough facts to show that the named traders had authority to trade on their behalf. The sixth one is joinder. The seventh is initiation. And the last one is the alleged non-compliance with the order of the CAC. I shall address topic 1, 3, 4, 5, and 8. Ms. Hobden will address topic number 2, which is the attribution of the conduct to the named respondents. Ms. Zikalala will address topic 6, which is joinder, and topic 7, which is initiation. To start off then, can I get my minute back? To start off then, which is on the question of the pleadings, and we will not make extensive submissions on this. But it's an important matter of principle that permeates the work of the Competition Tribunal, which is when a party is allowed to bring exceptions or to bring so-called applications for dismissal. What the Competition Tribunal has done in paragraph 23.5 of its ruling is that it decided that even if a party brings an application for dismissal, it will treat it as an exception. That is a very consequential finding, which we will urge this court to embrace. Because what it means is that the ordinary rules of exceptions apply, which means that the only admissible evidence or the only admissible allegations will be those contained in the Commission's pleadings and not new facts alleged by a respondent. That is the first consequence. The second consequence is that that ruling of the tribunal also avoids a scenario in which referral proceedings under Section 49B of the Act are essentially turned into motion proceedings, when the structure of the Act illustrates that these would be dealt with as trials. And it cuts across the entire case because some of the findings made by the Competition Appeal Court are based on new facts introduced under the guise of an application for a dismissal, whereas the normal rule of an exception is that there are no new facts other than those pleaded by the plaintiff, in this case, the Commission. And then the last consequence of it is effectiveness and efficiency of the tribunal proceedings. My learned friends who are all here are competition practitioners. They know how impossible it has become to prosecute cartels because we never get to the merits of the case. We are always held up in procedural objection after objection. This court also knows this because it expressly said so in the Standard Bank dispute involving the disclosure of a Rule 53 record under a so-called review. So it's important that the court gives a judgment that enables the Competition Tribunal to fulfill the objects in the Act, and particularly because there is a policy reason for the expeditious prosecutions of cartels. So that's a framing point about what's in and what's out. Let me then move to my first topic, which is the conduct that we say amounts to a single overarching conspiracy. The starting point is Section 4, subsection 1, subsection B of the Competition Act. That section, as the court knows, prohibits any agreement or concerted practice by firms who are in a horizontal relationship if that agreement fixes a price, whether it is a purchase price or a selling price, or if that agreement divides market, or if that agreement amounts to collusive tendering. This appeal is concerned with the first and the second category of agreements or concerted practices. In other words, those practices that are regarded to amount to the fixing of the price or to the division of markets, which includes division of customers. And the term agreement or concerted agreement, concerted practice, are important terms to keep in mind. The term agreement is not used in the Act in the definitions section in the same sense as an agreement in contract law. But an agreement in competition law is a broad thing that encompasses a contract, an arrangement, an understanding, whether or not it is legally enforceable. And the concept of a concerted practice is an even broader term because it includes cooperation, coordination between firms, which may be direct or indirect, but the key thing is that it must replace independent action with coordinated or cooperative action. And often it is easy for competition authorities to prosecute a firm that is alleged to be involved in cartel behavior or collusive behavior because the nature of that agreement would be obvious. There would be a piece of paper recording what the terms of the agreement were, and maybe there will only be a few firms involved. Often there will be a bilateral agreement, or maybe 3 or 4 firms. However, and this is what this case illustrates, cartels have evolved. They are now bigger, complex, and transnational. And this case is a classical example of a transnational cartel. Not only do the cartels not respect territorial borders or nationalities, they also do not respect any product in pursuit of profits. The courts would have read many cases of cartels. You know, people are fixing the price of the selling of oranges or the selling of bananas, many judgments like that in the European Court of Justice. But here what we have is something unique, which is that they targeted the sign of our sovereignty, which is the rand, in a perverse scheme driven by profit motives. And perhaps, if for anything else, for this reason alone, the judicial institutions of South Africa are the only institutions across the world that have a legal interest in the prosecution of this cartel. At the heart of it is the rand. To enable competition authorities to prosecute complex cartels that involve multiple participants, European competition law has developed the idea of a single continuous infringement or a single overarching agreement. Our own competition law has embraced this idea as a useful instrument in the prosecution of complex and transnational cartels. It was in this case at the Competition Appeal Court that the SOC idea was accepted and applied. We ask you as the Constitutional Court to also embrace the notion of an SOC as part of our law in line with the developments that have already taken place before the tribunal and the CAC, where the Commission, at least on this score, prevailed. The source of this idea, as far as we could determine, can be traced from the European Court of Justice's judgment in a judgment called Team Relocations. It's referred to at paragraph 28 of the judgment of the CAC. The facts of that case are not important, but it really identified 3 questions to be answered in order to know whether a single overarching conspiracy exists or not. The first is whether there is a pursuit of a common anti-competitive object, or the effect of that conduct is anti-competitive. So it's this anti-competitive object that is commonly pursued. That's question number 1. The second question is the contribution by each firm to that common object. And the third is the knowledge of each firm of the existence of the plan to pursue the anti-competitive object. And even if there is no actual knowledge, one still needs to ask whether or not it can be said that it was reasonably foreseeable that the firm must have known, and despite that knowledge, was prepared to take the risk. These 3 questions have been distinguished later to constitute really 2 areas. The first one being referred to as this anti-competitive object, and the second being attribution. In other words, who do you attribute the SOC to? And the first, which is the anti-competitive object, is an objective inquiry, and the second and third have elements of subjectivity, although they are objective as well. On the 25th of March 2025, the European Court of Justice, in a judgment that bears striking resemblances to this case, in a judgment called UBS Group and UBS Commission, we have included that in the latest bundle of authorities that was submitted yesterday. It is at page 11847, delivered 3 months ago. The European Court of Justice, where it dealt with the manipulation of euro-denominated government bonds, and if you read the judgment, it takes the same format as the currency manipulation in the instant appeal. At paragraph 923 of that judgment, this is what the court said in relation to the first element of an SOC. The condition relating to a single objective requires that it be ascertained whether the elements characterizing the various instances of conduct found have an identical object or identical anti-competitive effect, and consequently form part of an overall plan as a result of their identical object distorting the normal pattern of competition within the internal market. In the EU, they call it the internal market, but that's not relevant for us here. What's important for us is whether you can say from the pleading, you can discern a pattern of conduct that pursues an identical object or has an identical anti-competitive effect. In doing so, at paragraph 925, there are several factors that you should take into account. Number 1, the nature of the infringement. Number 2, the fact that the practices that have been employed in that infringement are similar. Number three, the fact that the goods or services are similar. And number four, the identical nature of the means of implementing the cartel. And number five, sometimes the identical geographical scope of that practice. One factor that is not in the judgment, but which we would add, is not only the geography, but also the period, the time in which this conduct took place. Not all of these factors need to be present, but the court must assess them cumulatively. What we stress in this case are these factors. There is a use of the common currency pair. It's the dollar and the rand. There are common participants. You see the same names over and over again. There are common features of the conduct. There are 5 distinct types that I will be dealing with. There is also a similar instrumentality, which is the use of the chat rooms, or where there are no chat rooms, the same trading strategies. There is also the same period between 2007 and, as far as we could ascertain, until 2013, although we cannot be sure if it ended, but it's the same period. And then, to borrow from the EC Bonds case, similar geographies, the United States and South Africa. What is also important, and again, this is a defense that comes across from many of these banks, it is not necessary to find that each bank participated in every form of conduct. It's not necessary in order to come to the conclusion of an SOC. It is not even necessary to conclude that each bank knew every facet of the SOC. It is also not necessary to find that each bank contributed to every form of the misconduct. One conducts a holistic assessment. What the ECJ judgment also finds in Eurobonds, which is paragraph 991 and 992. And in that case, the traders said to the court, my specific trader was involved only in 10 of the 900 instances. The court's answer to that was that that is a factor relevant to penalty. It should not be confused with the existence of the SOC. And this is what they say, specifically at paragraph 992. Moreover, it has already been held that the fact that an undertaking has not taken part in all aspects of an anti-competitive scheme, or that it played only a minor role in the aspects in which it did participate, is to be taken into account when the gravity of the infringement is assessed, and if and when it comes to determining the amount of the fine. So if you say, I was there only once, that's not a decisive factor to exclude you from the SOC. It is a factor for penalty. So right at the outset then, we need to stress that the Competition Appeal Court found that the Commission's pleading contained enough prima facie evidence to show that there was currency manipulation involving the rand and dollar currency pair. It also found that the form of that manipulation matched the pattern of a single overarching conspiracy. It was on the second question of attribution that the CAC disagreed with the Commission's assessment. It found that the pleading demonstrated that only 4 banks were involved in the manipulation of the rand that took the form of the SOC. Those banks were BNP Paribas, JP Morgan Chase, HSBC Bank or HBEU, I think that's their current name, and Credit Suisse Securities LLC, which is the overseas entity. That being the 2nd, 3rd, 14th, and 23rd respondent. And it's important to stress this point, is that the finding of the CAC is that the pleading contains enough evidence that the rand was manipulated, but it attributes that conduct to 4 banks and not the 27 that were initially cited. The CAC was not the only court that found enough evidence to show a prima facie case of the manipulation of the rand. The authorities of the United States have convicted traders, people such as Cummins, Katz, Ayer, the same players who are prolific here, of the same offense of manipulating the exchange rate involving the rand and the dollar. In asking you to endorse some of the findings of the CAC, particularly on the existence as a fact, as pleaded, obviously the probabilities will still be decided in trial, of the SOC whose object was to manipulate the rand, involving some banks, we also bear in mind that you will be following what other jurisdictions have already done to enforce competition laws in the prosecution of cartel activity, which involves the manipulation of the rand and the dollar. To return then to the findings of the CAC, we ask you to endorse the findings in relation, let me start with JP Morgan Chase, the 3rd respondent. Those you will find at volume 3, page 276 to 277, at paragraph 125 to 128. What the CAC did was to hold that the 3rd respondent was part of the SOC as pleaded. Why? Because its traders received information from Howes. Howes was employed by ABSA about what is referred to as bid offer spreads. I will deal with that later. That is paragraph 127. Secondly, they found that the traders discussed bid offer spreads with Howes. Thirdly, they found that the traders participated with Jason Katz in March 2012 in these chat rooms. These are the 3 forms of conduct that the CAC held brought the 3rd respondent within the ambit of the SOC. It is obvious that these 3 forms of conduct would fulfill the first element of an SOC, the common object to breach section 41B. If the discussion is taking place among competitors, and the court found that these were competitors involved in information sharing and discussing competitively sensitive information. And at paragraph 128, the CAC specifically finds the prima facie existence of the SOC as pleaded. In other words, it endorses fully the pleading of the Commission on the SOC. For the 2nd respondent, BNP Paribas, the findings will be found at page 284 from paragraph 147. This bank employed one of the central figures in the scheme to manipulate the rand. That was Jason Katz. And he was employed between September 2011 to July 2013. And the conduct there is the sharing of confidential information about the rand-dollar exchange rate in one of the prolific chat rooms, which was called the Old Gits chat room. So here what the court does take into account is the format of the SOC, which is taking place in this old JITS chat room, and the nature of the conduct, which is sharing confidential information about the exchange rates. Those are the two factors taken into account in BNP Paribas. For Credit Suisse Securities, which is to be distinguished from Credit Suisse Group, the findings are at page 280, paragraph 136. And the finding there is that Mr. Hutton, also one of the regular players in the scheme, is implicated because of his participation in the old GITS chat room, where he shared confidential information about bid-offer spreads. Also because of his frequency, he's a regular participant. It was found that the bank that he traded on behalf of Credit Suisse Securities was prima facie a part of the SOC. And then for HBEU, which is page 278, the 14th respondent, they are found prima facie to have been a party to the SOC because of the conduct of Mr. Hutton. Mr. Hutton was at HBEU between 2005 and 2010. I know there is a dispute, but this is the finding. And it says that the conduct in issue, the conduct of Mr. Hutton, is the conduct that is pleaded by the Commission, something we will get to shortly. So in sum, what is the CAC saying? It is saying that the nature of the conduct is the manipulation of the rand-dollar currency pair by banks who are competitors in the forex trading market. It also says that the nature of the conduct is sharing of confidential information, discussion of bid-offer spreads, and then it says sometimes we took into account the regular participation of a trader in that conduct. We took into account the reciprocal nature of that conduct, and therefore that conduct was regarded as being prima facie a breach of Section 41B. Now, HBEU says that they did not employ Hutton, and that the CAC is incorrect in finding that his conduct is attributable to them. But I would like the court to examine closely the pleading. The allegation against Mr. Hutton is at paragraph 65.71 of the Commission's referral. The referral is volume 5. At page 399. The actual allegation is that Mr. Hutton was employed by and or represented HBUS until 2010 and authorized by HBUS. Then it says, alternatively, its sister company, HBEU, to trade in the dollar-rand currency pair on its behalf. So one should not conflate the pleading with the question of employment. It's really a question of duly authorized. And there is good SCA authority on this. And the judgment is Northview Shopping Center versus Revelers Properties, reported in 2010, volume 3, SA, page 630 at paragraph 28, where it says a pleading that an individual is duly authorized is sufficient to meet an exception objection. There is no need to introduce evidence of the authorization. And therefore, it becomes an onus of the respondent to say that there was no authority. But the pleader initiating proceedings cannot be met with an exception objection where they use the phrase duly authorized. So that is the case against HBEU. If they did not employ him, that is not the same thing as saying he was not authorized to trade on their behalf. One must remember, these are sister companies. These are companies in the same group of companies. It's not as if these are companies that have nothing to do with each other. So we submit, therefore, that the CAC was correct in interpreting the referral affidavit as disclosing a prima facie case of currency manipulation that took the form of the SOC. But was the CAC correct in limiting the scope of the SOC only to these four? I want to show that had it not been for manifest errors of law, the CAC should have extended the scope of the SOC to more banks than it did. So what is then the scope of the COC? What is the correct scope of the SOC that we ask this court to embrace? As already stated, it is a question to be answered in the first instance by focusing on the alleged conduct, by looking at whether or not there is a common conduct that produces anti-competitive effects that is being pursued by these players. The conduct sometimes can be expressed, such as discussions in the chat room, but sometimes the conduct will be secretive, as is the nature of cartels. And in those instances, it would be admissible and probative to rely on what is referred to as conduct evidence, such as trading patterns or trading strategies, to infer the participation in the SOC. Insofar as the conduct, the affidavit specifies 5 categories of conduct which would constitute violations of Section 41B if established at the trial. The participation in one or more of these acts would demonstrate, we submit, prima facie and objectively the common object to manipulate the currency. Conduct number 1 is sharing of information on bid-offer spreads and colluding on the spreads. Now, the court no doubt has gone through the referral. It would have noticed that this is the most common form of the collusion. And this is also most common form even when you read the Easy Bonds case. What the spread is, perhaps can be explicable by an example. If you are a buyer of currency, a customer, what you are trying to do is to buy the currency for as low as possible. But if you are the seller, you are trying to sell for as high as possible. So for an example, you could say that as a buyer, I'm only prepared to pay R7.20 for $1, and that's the highest amount you would pay. But the holder of the dollar, the seller, could say, I am not prepared to go below R7.30, and that is the lowest. Now the difference between what the buyer says and what the seller says is what is called the spread. And in the example that I've given of R7.20 and R7.30, the spread will be 0.10. Now you could see from the example that I've given that this is highly sensitive information because only you as either the buyer or the seller know your spread with your customers. So when we as competitors share the spread, we collude on it, we impair competition because it amounts to information sharing or price fixing. And this is not a controversial topic. The CAC has itself made this finding that sharing information on bid-offer spreads is collusive conduct, prima facie, that calls for an answer in respect of the 4. And the tribunal has also made the similar findings. There is the instance at paragraph 119, which has generated a lot of heat. But it is also illustrative of the problem of information sharing on spreads. And it is in relation to Standard Bank. and that is at volume 5, page 416, where the allegation says, on 1 October 2012, Taylor was employed by Barclays Capital. I know that Standard Bank says he was not employed by Barclays Capital, but it's part and parcel of the problem of anticipating a trial in motion. But the allegation is that Taylor was employed by Barclays Capital and Brownrigg was trading on behalf of Standard Bank. But the allegation says, on 1 October 2012, Taylor and Brownrigg were participants in an implicated chat room in which the following communication took place. Taylor inquired what quote Brownrigg would show a top customer in 25 and 50. Brownrigg responded by telling him 50, 100. Now this comes to this question I was talking about information sharing. What the two, these are competitors. I know that Mr. Sinton says Barclays Capital is not a competitor because it doesn't engage in Forex, but that's a matter for the trial. But what I'm illustrating by this, it appears benign when you first read it. But when you actually examine what are they talking about, they are talking about a customer as competitors, about what price would be offered to that customer. It's a classic instance of price fixing, because what they are doing is they are making available information that ordinarily ought to be confidential between them and their customers. And this is the core problem of cartel prosecutions. What competitors ought to be doing is to win market share, which means winning over customers. But when they're busy discussing what price would be offered to the customer, that's a classic instance of price fixing. It's removing the veil of secrecy and the trick of competition with transparency. And it's doing what the definitions say, which is replacing independent action with coordinated action, which is what Section 41B at its heart is about. The second category is the coordination of trading activities. What the banks, and you will see this, the allegations on the first strategy are at paragraphs 95 to 119 of the pleading. In relation to the second strategy, which is the coordination of trading activities, you will find them from paragraphs 131 to 159, pages 419 to 423. So what we mean here about coordination of trading activities is actually a very simple thing. The banks would share information about future trades. I will be placing this trade at X time. And then sometimes they would intentionally hold back their trades. Say, I won't be trading. I want to allow you to trade instead. Or they would put in a trade and then pull it back in order to allow someone else to trade. Now again, this is a form of currency manipulation. It is a breach of Section 41B, pulling back a trade to allow a competitor to trade in your stead is market division. You are dividing customers, you are allocating customers. And customer allocation is prohibited by Section 41B. It's the second of the three instances that are expressly stated in the Act. The third category is what is called coordination of trading at the fix. So this requires a little bit of explanation because it's technical. I hope Professor Chris Malikane will forgive me if I botch the lectures he has given me on the subject. But the fix is the price of each currency determined on that specific day, published on the Reuters platform. So on each day, the price of each currency is published on the Reuters platform. This is sometimes referred to as the benchmark exchange rate. And it's commonly used primarily by institutional investors. But the way it's calculated is that it averages.
Sorry, Mr.
trades.
Wait, so just go back there where you were explaining it.
Yes.
So I don't want to miss you there. Sorry to interrupt you.
No, that's fine. Let me start at the beginning then. So the third category is the coordination of the trading at the fix, FIX. That's different from FX, which is for Forex, but this is FIX, trading at the fix. Now, what is the fix? The fix is the price of each currency. The rand has a price today. It will be published at 4 p.m. by the Reuters platform. And every other currency has a price. They will say, if you have dollars, you want to buy rands, this is the price. If you have pula, you want to buy rands, this is the price. Everyone, there's an exchange rate that is published for every currency. And it is sometimes used as a benchmark exchange for each a benchmark exchange rate. And the people that tend to use it primarily are institutional investors, like your pension funds, because they don't like the volatility of the currency. So they want something predictable. So they will say to them, I've got this money, I need you to go and buy me dollars at the fix. So in other words, the rate you must use when you buy dollars is the rate that will be published at the fix at 4 o'clock. And I will know what the fix is because it will be published. Now, the way that fix is determined, it averages the trades in that currency that take place 30 seconds before 4 p.m. and 30 seconds after 4 p.m. every day. This is why the traders call this the 4 p.m. fix. Because at 4 o'clock, the price of the rand is published. And then some people use that as a benchmark for when they engage in the trading of the currency. Now, the allegation here is that what the banks were doing, they were coordinating trading in order to influence and control the rate at the fix. So by pushing volumes or withholding volumes, you can then influence, because the way it's calculated is the 30 seconds before and the 30 seconds after. So you could create an artificial demand or create an artificial supply constraint by withholding. Now you will see this from paragraphs 169 to 172. And this strategy of withholding quotes was actually quite common among the South African banks, RMB, Nedbank, Standard Bank. And those are the banks we don't have participation in the chat room. So that's the third strategy. It appears complex, but it's actually a simple thing, which is the coordination of trading at the fix. And then the fourth strategy is to manipulate the actual exchange rate. There are different ways of manipulating the exchange rate, and the court will find various explanations. I could identify paragraph 185, paragraph 190, paragraph 234 in the pleadings. And the ways that they used to do this is by putting what is called a fake bid. You pretend as if you want to buy, but you're going to withdraw the bid within a second. It's a fake bid. And then you notify your colleagues that I'm just about to put a fake bid. If you want to match me, you can on the fake bid, but fake bid is one of the strategies. And then they would create what is called focal points. And I'll deal with a focal point earlier because one of the banks goes on about a focal point not necessarily being collusive, but that's inconsistent with the pleading. And the focal point is then the point around which the other competitors would price. It's always by definition collusive. And as I say, some of this coordination, which is the actual manipulation of the exchange rates, did not necessarily take place in the chat rooms. But it did involve our local banks. And that will be evident from the nature of the conduct, which is consistent with the coordination in the chat room. So if you put the chat room here, and you put the conduct here, the two actually match. What is discussed is what you see in practice. And that's why one should not be beguiled by this idea, where is my trader in the chat room? This is just obfuscation. And then number 5 is the general strategies to increase market transparency. By the constant sharing of information, there was an information overload among these competitors. At all stages of the trading, from customer inquiries to the actual placing of the trades. So the 5th part, again, the CAC made this finding that there was a general increase in market transparency, which is the opposite of competition. So these are the 5, and you will find this at page 441, paragraph 238 of the pleadings. So these are the 5 core strategies that were used. And as I say, the most common was the information exchange on bid offer spreads. All of these conducts, all of these 5 strategies are prohibited by section 41B. And each participant that took place in it was acting in breach of the Act. And objectively speaking, because of the overlapping conduct and the overlapping product, this was same anti-competitive conduct. So how about the second leg of the test, which is attribution? Ms. Hopton will go into detail about this, but I need to just set out some general principles right now. We've extrapolated 6 factors based on paragraph 992 of the EC bonds case that we say are indicative of this pattern. Number 1, there is a core group that has been found by the CAC to have been involved, and then there is other players. They may be peripheral, but they are part and parcel of it. But there is a common conduct. They are doing the same thing over and over again. Number 2, there is an expectation of reciprocity. Now, the reason we say this, there's an expectation of reciprocity, because it becomes important when we deal with bank-by-bank analysis. There is no point in disclosing your bid offer spread to your customer, to a competitor, if you don't expect reciprocation. Right? It's because they must also tell you theirs. That's the only way the scheme can work. There's no point in saying, I'll tell you mine, because you're just pricing yourself out of the market, which is just silly. So the expectation of reciprocity is another indicator. Number 3, this similar currency, and I've said this before, the similar currency, it's rand and dollar. That's why Katz is in prison in America, Aya and Cummins. That's why they were all arrested. Rand and dollar, same currency. Similar period, I've already dealt with that. Similar methods that are used, and then similar geographies, US and South Africa. And these are the factors that we say illustrate the pursuit of the anti-competitive outcomes, and therefore satisfy the first element of team relocations in identifying an SOC. We can then move from these general principles that I've been trying to outline to show how the CAC simply got the law wrong and misconstrued the pleading when it decided to exclude some of the banks from the scope of the SOC, which is characterized by the features I have outlined. The first group of banks excluded is Barmley, Merrill Lynch, Bana, first, 20th, and 21st respondents. Why do we say that the CAC simply misunderstood the pleading? The pleading says that these banks were represented by Shepard and Cook in the chat rooms. The CAC says that there was no evidence that Shepard participated in any of the discussions. This is an error of law. The law does not require Shepard to have been a participant in a chat room. It requires him to have been a member of the chat room. Because one of the strategies that are used to collude is increased market transparency, is information sharing. So by being present in the chat room, he acquires the knowledge. There's no need for him to speak. He's in the room where the collusion is taking place. As for Cook, the CIC held that there was no evidence that he conspired with a South African bank. I need to clarify this right now. Whether he conspired with a South African bank is not relevant to the existence of the SOC, because the SOC's inquiry is the question of the participation in the manipulation of the currency. It is only relevant to the issue of jurisdiction, not relevant to the issue of the SOC. The problem here is that the CIC left the central question, which is whether or not Cook's conduct on behalf of either Merrill Lynch or Barmley fell within the terms of the conspiracy. And this was a material error of law. That question is in fact answered in the Commission's affidavit. The Commission's affidavit places him and Shepard squarely within the ambit of the scheme of the manipulation of the rand. Why? Cook was a member of the Old Gits chat room. He was a central player in that chat room. The CIC itself held that that chat room was the most prolific platform in the design and implementation of the conspiracy. Cook was a regular participant in those discussions and a regular participant in the conduct. If you just take the pleading and you count the number of times Cook appears, it's 40 times. He is either present when the collusion is taking place, or he is himself engaged in the collusion. And he is implicated in all of the different categories of the conduct. The question of Cook's authority is addressed specifically at paragraph 65.6 of the pleading. And it goes back to the question of authorization. We say he was employed or alternatively duly authorized by one of the three. 65.6, Deputy Chief Justice. Yes. Now they say, no, he was employed by Merrill Lynch. That may well be, but it doesn't answer the question whether he was authorized by the sister company. And we have given you SCA authority, and we say that employment is not required to be proven. So Cook brought them within the scope of the SOC. Then there is Australia, New Zealand, ANZ. They are connected to the conspiracy through Mr. Katz and Mr. Tezel. The CIC found that Mr. Katz left his previous employer and joined ANZ after 2012. And the pleading stops the conduct of Mr. Katz in 2012. And therefore, when he joined ANZ in 2013, there is no conduct pleaded that is attributable to him. But what the court has overlooked here is that the Commission says that it doesn't know when the conspiracy ended, if it ended at all. So quite probably, the conspiracy proceeded beyond 2013, and ANZ would be clearly implicated through the conduct of Mr. Katz. The pleadings will come from ANZ, and they will tell us whether or not they acquired any knowledge of the participation of Mr. Katz post-2013. And I want to refer here, and I'm not going to read them, to paragraphs 309 to 314 of the judgment of the EC Bonds case, the European Court of Justice, which found that knowledge acquired by a trader in a previous employer can be attributed to a new employer if it can be shown that he disclosed it to that new employer. That's the law. So we can take what you acquired from the old to the new. The CIC then speculated that the Commission had access to the investigation record of the US Department of Justice. But there was no basis for this speculation. And then another trader is Tezel. And the court will have regard to paragraph 96 of the judgment, page 267, volume 3. It seems what happened is that the CIC just misunderstood what the Commission was saying in this paragraph. The Commission says in this paragraph, Madras, Tezel, and Aya were in the same chat room. So Aya is one of the main players in the scheme. Madras is employed by Citibank, which is a leniency applicant, having confessed to its participation in the currency manipulation. So the connection is these two other players, Aya and Madras. And that is why he is then able to cut and paste the communication and place it in the chat room, is because he has access to at least, we don't know how many people, but at least a 3-member chat room that involves Aya and Madras. So we respectfully submit that it seems that there was just a misconstrual of the referral. Nomura, which is dealt with at page 268. That case begins at paragraph 194, page 433, yes. And the conduct begins on the 27th of May 2010. And the allegations there are that several banks, Nomura, HSBC, Absa Standard Bank, held the rand at various focal points. At one point, they held it at the focal point of 7.57 Rand. Later on, it was reduced to 7.56 Rand. And that was a scheme, that is what is in the allegation, a scheme designed to enable them to sell rands, which they did simultaneously to gain USD profits. They also did the reverse simultaneously in order to gain rand profits, which the allegation says weakened the rand. This is clear coordinated conduct. Then there is the date of the 2nd of March, where 2 instances are cited at paragraph 254 and 256. The first instance is Alan. Alan is a representative of Nomura. He is in the same chat room as Katz. Katz is known to be the frequent player in the conspiracy. He is in jail at the moment for manipulating the rand and dollar. On the same date, he is also in discussion initially about the disclosure of customer information, but then later on about customer codes. Again, these two are found to be collusive. And then finally, there is an additional player, which is Dempsey. And that you will find at paragraph 114, page 415. Now, Dempsey is not talking to Katz this time, but he is colluding with Howes. Howes is employed by Absa. Absa is a leniency applicant. What are they discussing? A bid offer spread, which is the most common form of the collusion. So Nomura is in the SOC. Commerce Bank, the case there starts at paragraph 251, where Dowsey, who is the representative of Commerce Bank, is in discussions with Katz. What are they talking about? They are talking about a customer in the market. But moreover, at paragraph 231, it is alleged that Commerce Bank initiated a focal point. Now, let me just spend 1 second on this issue of the focal point, because the CIC speculates that the initiation of a focal point could have been unilateral conduct, in other words, independent action, if you look at the definition of coordination in the Act. They speculate that this could have well been unilateral conduct. But in that speculation, they misread the pleading. The pleading explains what the focal point is. I want to refer the court to paragraph 185.4 of the pleadings, where it is stated that these focal points, in other words, the point of the trade, so the focal point of today is going to be 7.56 Rand. They are created by coordination. Banks agree what the focal point is going to be. And then at paragraph 187, a focal point is specifically defined as the level of the spot rate at which coordination takes place. So far from being benign, a focal point is collusive. So the accusation against Commerzbank at paragraph 231 is that together with other banks, it's the leader in the initiation of the focal point. There is no point in initiating a focal point if it is not multilateral. It only makes sense if it is multilateral. Then it is alleged at paragraph 233 that they coordinated a match in the average of the bid and ask price with Investec at 8.32 Rand to the dollar. This stands to reason. I've already explained this at length. And then again at 234.2, it is alleged that it matched with RMB its bid and ask spreads at least twice. And again, these bids and ask spreads is the most common form. It's really your profit. And so matching it with your competitor is collusion. So we have a problem with the Commerzbank because the CAC simply made speculative findings that are not grounded on the pleading and simply overlooked the contents of the pleadings. There is also an irrelevant discussion that is introduced around Commerce on Mr. Sintin, who was an employee of Standard Bank at the time, and the fact that he said that the Reuters information platform shares publicly available information. But this is a misdirection. This has nothing to do with the Reuters platform. It is true that your actual quote as a bank is put on a screen that everyone else has access to, your actual price. But what is not put there is your discussions with your customers, which is what these banks did, is what they made transparent, is the agreements with their customers. So whatever Mr. Sintin said about the Reuters platform, it is irrelevant to the collusion that took place about bid offer spreads, about matching, about focal points. Then Macquarie, we must admit here that there is only one reference to Macquarie. It is at paragraph 116. The problem here is that the CAC holds that the conversation between Macquarie and ABSA, and by the way, it's a conversation with ABSA, a leniency applicant, could well have been bilateral. And it's unclear here whether they mean it's bilateral and therefore it's not part of the broader SOC, and therefore it could just be an agreement between two parties. But what that reasoning does is to overlook the nature of that discussion. And I said this is one of the crucial elements you look at in knowing whether an SOC exists, is the nature of the conduct. The nature of that conversation is about bid offer spreads, which the CAC has found elsewhere is confidential information, and in fact was at the heart of the collusion. And here it was shared between competitors, ABSA and Macquarie. And ABSA is a leniency applicant. So we say, although you will take into account that Macquarie is a one-time participant, when you consider the counterparty, ABSA, when you consider the nature of the conversation, it fits the fact pattern of the SOC. So they are in the SOC themselves. And this is all taking place in the chat room. I want to then spend the next 10 minutes on the local banks. Nedbank, Standard Bank, RMB. Also to illustrate how the CAC misinterpreted the pleading. And one of the most glaring failures of the CAC is the absence of any meaningful analysis of the impact of the trading data. But in cartel cases, economic evidence or trading evidence is as valuable as communication evidence. They focused only on the express communication in the chat room and did not pay attention to the unexpressed conduct. There is a paper that I would refer to the court, which we have, and I'm not going to read them, it's long paragraphs. But the paper appears in the supplementary bundle of authorities at page 12041, and it's called Prosecuting Cartels Without Direct Evidence of Agreement. And what it did is to examine national jurisdictions about the problems that competition authorities face all the time. What do you do when you don't have the smoking gun? You never got the guys inside the room discussing the price. But what you have seen are patterns in the market. You've seen when you go to Pick and Pay, a loaf of bread is 12 rand 56, shortbread 12 rand 56. This 12, what is going on? What do you do in those instances? They say that you should not discard economic evidence, conduct evidence. Sometimes conduct evidence is indicative of collusion. And sometimes it will require an expert to explain these patterns. And sometimes it will correlate with express evidence. So the things you see, they say in the chat room, versus the things you see are happening in the market. Those two sometimes will correlate. But the important point is that you should not discard communication evidence. It's admissible and it can be probative. And we are in an exception stage, justices. We are in an exception stage. We are not in the trial yet. The weight to be placed on the evidence is yet to be determined. So the glaring failure here is the dismissiveness of the economic evidence, when every indication is that this was very important evidence that should have been taken into consideration. But even the CAC itself, in a case called Aranda, paragraph 36 and 37, Aranda is in the bundle of authorities, has embraced the use of economic evidence in the investigation and prosecution of cartels. When you don't have direct evidence, what do? And all you have is patterns of behavior. So we submit here that you should look critically at the CAC's complete failure to meaningfully analyze conduct evidence. Here, what the conduct evidence does show are the same anti-competitive patterns that we see manifested in the chat rooms. Let us start with Standard Bank. I have already dealt with the conversation between Brownrigg and Taylor of the 9th of October. There is an earlier one of the 19th of September 2012. What they were discussing there, Brownrigg and Taylor, is the actual spread, the spread of 0.1. And we now know that the spread is in fact another way of expressing the price. So you have an agreement that is pleaded that they agreed on a spread of 0.1. And secondly, that spread of 0.1 was a spread agreed with the other banks as well. So that is anti-competitive object being pursued right there. But moreover, and this is all express evidence that is contained in a chat room, but moreover,
Ngokaitobi, you said you're going to spend about 10 minutes on the SA banks.
yes, I think I've done fine.
We've reached 11:50.
Oh, yes, sorry.
Yeah.
I thought it was a criticism on me, but it's not. All right, yes.
Is it an opportune time to take the break now?
Indeed.
Yeah, we'll come back at 11:31.
As you please.
So this is the last one.
But there is a trader in each bank because these banks were trading. The only difference is that the Commission does not know the identity of the trader. And the same strategies are employed. So each bank knows what the case is against it, and each bank was correctly brought within the ambit of the SOC. And the findings of the CAC, one of the more egregious findings of the CAC is that it did not even consider the case against Nedbank at all. Nedbank does not appear in the judgment of the CAC. And yet the court complains of errors made by the tribunal, but it just introduces new and more serious errors in its own reasoning. So we would therefore submit that the chat room evidence taken cumulatively with the conduct evidence shows that all of the banks we've cited were correctly joined in the SOC. What we propose doing, Deputy Chief Justice, is for me to allow my colleague, Ms. Hobden, to address the question of attribution because it follows logically from what I have addressed. Then I will come back on the other small topics. Thank you.
Deputy Chief Justice and Justices of the Court. Mr. Nqotobi has demonstrated to this Court that the Competition Appeal Court and the Tribunal have accepted that the referral affidavit pleads the existence of a single overarching conspiracy. He has also demonstrated how the Competition Appeal Court erred in assessing the allegations in the referral when determining whether a sustainable cause of action had been pleaded. From a reasonable, intelligent, and holistic reading of the referral, we can see that the referral contains allegations that each of the respondent banks have engaged in conduct that contributed to the SOC and pursued the same overarching objective. My task today is to engage a little closer at the referral in order to demonstrate the second component necessary to establish a cause of action against the banks. And as Mr. Nqotobi mentioned, that is whether there are sufficient allegations in the referral to establish that the respondent banks knew or that they ought reasonably to have known or foreseen the scope and general characteristics of this overarching conspiracy. And this was not an exercise conducted by the Competition Appeal Court at all. Now, this finding on knowledge or awareness, or imputed knowledge or awareness, will be made by the tribunal at the trial after all of the evidence has been laid. They will make findings based on direct evidence. For example, if Mr. Arlen on the stand concedes that he knew everything about the conspiracy because Mr. Iyer had told him, that would be direct evidence of knowledge. But of course, the tribunal may also draw inferences from the proven facts at the trial. And the tribunal will apply the test for drawing an inference at trial, but that is not the test that is applicable today. The test at exception stage is different. In this context, to resist an exception, the Commission must simply show that the referral affidavit contains allegations from which a reasonable possible inference can be drawn. And that is the standard set by the tribunal in the Tourvest Holdings case. So we will analyze the conduct pleaded against each bank, which Mr. Nqotobi has done in his address, as well as the relevant surrounding facts. And then from these factual allegations in the referral, we will ask ourselves if the tribunal, if a reasonable possible inference can be drawn that the particular bank knew or ought reasonably to have known of the scope and general characteristics of the cartel. And to remind ourselves of those general characteristics and the scope of the SOC, it has an overarching objective to manipulate and distort normal competition conditions in the trading of the US dollar and rand currency pair, it has particular forms of conduct for its implementation. That conduct required mutual cooperation between banks. It also involves banks with a presence in South Africa, insular banks, and international banks. And it was implemented primarily in chat rooms on the Bloomberg platform. We will look at 4 main factors outside of the individual bank's particular conduct. Facts regarding the nature of the conduct in which they participated, facts regarding the identity of traders or firms with whom they had contact, and facts regarding the nature of the communications, and facts regarding the established knowledge derived from their own conduct. So I will demonstrate to the court that, properly read, the referral contains sufficient allegations of direct conduct of respondent banks and of relevant surrounding facts from which we can draw a reasonable possible inference that each of these respondents knew or ought reasonably to have known of the scope and essential characteristics of the SOC. And to note that each of the participants does not have to know everything about what every single person is doing in this conspiracy. And frequency of participation in the conspiracy is also not the only factor that can give rise to an inference of knowledge. Just up front to note that the analysis of the referral will be done on the basis of the Commission's case, which is essentially that the principles applicable to exceptions apply. We take the allegations as correct. We don't admit extraneous evidence, although we also say that even if one does admit the various affidavits of the banks, we still establish a case. We're permitted to adopt a generous interpretation of the pleading, and we are permitted to rely on both direct allegations and on inferences that can be drawn in order to establish a case on exception. With this framework in mind, we can begin. I'd like to start with 6 banks who have a common feature. There are 6 respondent banks who are alleged to have employed a trader in the central chat rooms where collusive conduct occurred and was planned. Those 2 chat rooms are known as the Old Gits chat room and the ZAR chat room. They had members in common, in particular Mr. Katz. He was a member of both of those chat rooms. These banks are the 28th respondent, Standard Americas, who employed Mr. Katz from 2001 to 2010. The second respondent, BNP, who employed Mr. Katz from 2010 to, I think, the end of 2012. HBUS, the 19th respondent, who accepts on affidavit that it employed Mr. Hatton from 2007 until October 2010. And as Mr. Nkotobi has mentioned, there is a dispute there about whether the conduct of Mr. Hatton can also be attributed to HBU, the 14th respondent. We don't need to deal with that for now, even on the fact that we look at his conduct and we can deal whether it's attributed to HBU as well. But for present purposes, it's accepted by HBUS that they employed him. The 23rd respondent, Credit Suisse, who employed Mr. Hatton after he had been employed at HBUS. And the 20th respondent, MLPFS, who employed Mr. Cook, and that they have accepted on affidavit as well. And as Mr. Nkotobi mentioned, and will address later, there is also a dispute there about whether Mr. Cook's conduct can be attributed to Bana and Bamley as well. We say yes, they say no. The other members of the Old Gits chat room was Mr. Cummins from Citibank and a couple of traders from Standard Chartered. Those parties are not before the court. So it is a big chat room with many participants from many different banks. We then have the ZAR chat room, and that is the chat room in which Mr. Ayer, the trader from JP Morgan, was a member. The other members of that chat room, apart from Mr. Katz, were Mr. Cummins from Citibank and Mr. Williams from Barclays Capital. So what's important to note about the pleadings in relation to these 2 big chat rooms is that there are allegations that each of these traders, Cook, Hatton, Katz, were members, and Aya were members and participants of these chat rooms. And we can see within both chat rooms, and particularly the old GITS chat room, all of the forms of conduct comprising the SOC taking place. These forms of conduct may take place by different traders on different days. Sometimes they are active, sometimes they are passive. But all of the forms of conduct that Mr. Toby has mentioned happen inside of this chat room. And we can look at a few briefly. The first is collusion on the bid-offer spread. And here we see at paragraph 106, we see members of the old GITS chat room where Cummins asks the other participants what bid-offer spread they were quoting customers, and Mullaney responds. They also engaged in manipulation of the exchange rate. At paragraph 189 is a good example of this. These traders in the chat room, McKerney proposed to manipulate the US dollar rand pair rate by whacking quotes in order to increase the rate. Katz warned the other traders to be cautious, to check that there are no other trades that could interfere with the manipulation. He asked another trader to withdraw his offer quotes so that they could all profit from the manipulation. And Hatton encouraged other traders by suggesting that the profitability of the proposed manipulation and trades could be significant. The members of the old GITS chat room, and within this chat room, we also see multiple instances of collusion with respect to the fix. And we find these at paragraph 162 and paragraph 168. Firstly, the traders exchange competitively sensitive information, and then Katz and Cook agree to coordinate their trading at the fix. Not too long after that, the traders offset their respective positions at the fix. Both forms of collusion in relation to the exchange rate as it's set at 4 o'clock on the Reuters platform. We also see multiple instances of the exchange of competitively sensitive information, reducing increasing transparency in the market. Paragraph 104 demonstrates this quite well. Hatton and Cummins share information on bid-ask spreads, that's on the price and profit that they're going to make in their business of buying and selling rand. Hatton tells the other participants the current HSBC strategy on the rand-dollar pair. Cook asks Katz about the current trading position of the Johannesburg office, and Katz responds. Cummins shares information on customer orders. We also see these participants in this chat room coordinating their trading to withhold trades or to pull them, depending on what would benefit the other traders in the chat room. And examples of this are at paragraph 125, where Katz and Cummins discuss that Katz will withhold trades for Cummins, and at paragraph 161, where traders in this chat room pull trades. Cummins asks the other participants to pull their bids temporarily to secure his favored position at the fix. So we've seen all of the forms of conduct taking place in this one chat room. And the same goes for the ZAR. I don't need to go through those examples. We also see that the referral alleges that these particular traders, Katz, Cook, Hatton, and Aya, they actively participated themselves in multiple instances of these forms of conduct. And in other instances, they were passive participants in the chat room. They were present in the chat room where their co-conspirators were engaging in this very conduct. The referral also pleads that they had access to past history, so when they entered into a chat room, they could scroll down and look and see what everyone else had been talking about before they logged on. If one just flips through pages 411, 412, and 413, you can get a very good selection of the kinds of conduct and the particular instances. So we know facts about the traders in this chat room, and we know facts about this chat room. So what are the reasonable possible inferences that the tribunal could draw in relation to these parties' knowledge or assumed knowledge? First of all, they were most definitely aware of all of the conduct alleged to form part of the overarching conspiracy. That is because they participated in it. They were actively doing it, so they were aware of it. They were also present for their co-conspirators' conduct. Their presence in the chat room means that they were aware of what everyone else was doing in that chat room, and they had access to what they had been doing, even if they weren't in the chat room at the time. They were aware, or ought reasonably to have been aware, that the collusive conduct was occurring between multiple firms. They knew who the members of their chat room were, and they knew what firms they worked for. They were also aware, or ought reasonably to have been aware, of the international nature of the cartel, that the collusive conduct was happening between firms with a presence in South Africa, international firms. And they were also aware of the consequences and effects of their conduct. And perhaps the argument that you will hear from some of the respondent banks is that it is not possible to infer that these players could reasonably have known that this conspiracy extended outside of their chat room. But that makes the same mistake that the CAC made when it looked only at the issue of the frequency of participation. There are multiple other facts that one can look at in order to draw an inference that these traders must have known that this conduct was happening elsewhere and in furtherance of the same aim, or they ought reasonably to have been aware, taking into account all of the facts. First of all, it's the nature of the conduct. This chat room involved multiple participants from competing firms. There was frequent communication, and they were using a platform for private conduct that they knew was accessible to other traders. They knew about the benefits that membership of this chat room and participation in the cartel would give other traders. At paragraph 240, Katz thanks other traders for their assistance. At paragraph 97, Cummins says he needs to support his family, so please can the other traders assist him. And at paragraph 189, Hatton encourages the traders by saying, well, this is very profitable and the trades could be significant. Secondly, the majority of these members in the old GITS chat room had separate bilateral communications with traders from other banks outside the chat room. Mr. Katz had many conversations with many people. As I've mentioned, he was a common participant in both the ZAR and the old GITS chat room. He also had contact with Mr. Dowsey, Mr. Howes, Mr. Serrana, and Mr. Majakovic. Similarly with Mr. Ayer, who had extensive contact with Mr. Howes and with Mr. Arlen. There was certainly no secrecy in this group about the fact that these traders were talking to other people outside the group, and we see that because there's references to discussions of other members during this conduct. So with these facts in mind, it's certainly reasonable to infer that these traders who were engaging prolifically in the conduct themselves reasonably ought to have known that other traders were doing the same to derive the same benefits and using the same platform. So what we see in relation to these 6 banks, potentially 9, is that there are allegations demonstrating that the conduct falls within the scope of the single overarching conspiracy, and there are allegations from which to infer awareness of the full scope and general characteristics of the SOC, and at the very least, that objectively these traders so deep in the collusive cartel ought to have foreseen it. And that is sufficient at exception stage to establish a cause of action and to require all of these banks to answer the case against them. I'd like to move on to some of the other respondent banks. Firstly, the 8th respondent, Standard Bank. Mr. Ngcotobi has dealt with this in some detail. Standard Bank is alleged to have been represented by Mr. Brownwick in these interactions. And the allegations are that he was a participant in a chat room and that there are Standard Bank's conduct in the market. So it's a combination case. Together, all of these allegations against Standard Bank cover the main forms of anti-competitive conduct comprising this cartel. They involve collusion on bid-offer spreads. Those are the discussions between Brownwick and Taylor. Very clear example of sharing of information and colluding on what profit each of these banks should be making when they engage with customers. We also see the unusually high spread of 0.1 being charged by the banks for long periods of time. In paragraphs 192 and 192.3 and point 4 and point 5, we see the same bid-ask prices being posted for 7 hours by a number of the respondent banks, including Standard Bank. There's also coordination of trading at paragraph 235, and there's also manipulation of the exchange rate at paragraph 194, 95, and 187. And of course, the sharing of competitively sensitive information through the discussions with Brownrigg and Taylor. So what can we see from Standard Bank's knowledge from these allegations? From the actual allegations about Standard Bank's own conduct in this cartel, they were aware or ought reasonably to have been aware of the core conduct that is alleged to form part of this single overarching conspiracy, and that is because they participated in it. They colluded on bid-offer prices and the spread, they manipulated the exchange rate, they coordinated their trading, and they shared competitively sensitive information. And they did so repeatedly. They were also aware that there are multiple other banks involved in the same anti-competitive conduct, acting with the same purpose and for the same objective. They're aware of Barclays Capital, they're aware of ABSA, Nedbank, and First Rand, and they are aware of the international banks, Standard Americas, Nomura, and Barclays. They are also aware, or ought reasonably to have been aware, of the consequences of their conduct. The referral pleads that they could see in real time how what they were doing was impacting the exchange rate. And we also see that they could see that the spread was being held at 0.1 by all of their co-conspirators. They were also aware of the mode of implementation of this conspiracy and how these strategies would benefit them. And we see that where Standard Bank dominates the market at paragraph 235. But beyond this, Standard Bank was also aware, or ought reasonably to have been aware, that the SOC extended beyond their own conduct. And we draw this inference from the facts that are already established in the referral, that there is the existence of the SOC with this very conduct. And also the nature of the conduct in which Standard Bank was engaging. It required mutual cooperation, it required quid pro quo. It required multiple banks to be involved. The more the merrier, one might say. There are also factual allegations about the identity of the traders in which Standard Bank was colluding. Barclays, Capital, and ABSA. Standard Bank was engaging in anti-competitive conduct with respondents who did have traders in the chat room on the basis of the referral. The conduct with ABSA, who had a trader who was prolific in the chat rooms, Howes. Conduct with Barclays Capital, who had a trader in the ZAR chat room, Williams, and conduct with Standard Americas, who had a trader, Mr. Katz. So the identity of the traders is objective facts from which one can draw an inference that Standard Bank would have known through its engagement with central players in the conspiracy, would have been able to, knew or ought reasonably to have known that this conspiracy was broader than what it particularly was doing. We can also look at the nature of the communication. Taylor and Brownrigg suggest that the discussion there suggests a comfortable relationship where they can exchange information. Certainly one can infer that this has happened before. So from this context, we can establish that Standard Bank knew or ought to have known that when it participated in this conduct, it was acting anti-competitively, it was doing so with many different banks, and that its conduct was part of a broader underlying plan. And from that pleaded conduct viewed holistically and these surrounding relevant facts, the tribunal most definitely could draw a reasonable probable inference that Standard Bank was aware or ought reasonably to have been aware of the scope and essential characteristics of the pleaded conspiracy. The next bank to deal with is Nomura. It is also a bank in which there are allegations of a trader in a chat room and conduct data. Nomura's employees are Dempsey and Arlen. Dempsey was a participant in a chat room with Mr. Howes, and Arlen was a participant in a chat room with Mr. Williams, Aya, and Katz. Now, we've heard their names before. They are the core members of the ZAR chat room. There are also allegations of Nomura's conduct in the market. paragraph 194. And once again, we see this conduct falling across the main categories of conduct that form part of the conspiracy. The collusion on bid-offer spreads. The discussion between Dempsey and Howes was one about bid-offer spreads at paragraph 114. We see the manipulation of the exchange rate at paragraph 194, and we see sharing of competitively sensitive information in the chat room where Arlen is a participant, and he's present where Williams tells participants about customer orders, and Aya shares information about customer quotes. So if one has to look at what inferences of knowledge one can make, or what findings that these traders ought reasonably to have known, certainly they knew about the core conduct forming part of the conspiracy. They participated in it. They were also aware, or ought reasonably to have been aware, of the objectives of this conduct and its effect. They were professional traders. They were watching in real time. They were also aware, or ought reasonably to have been aware, that multiple other banks were doing the same conduct at the same time. Their traders were engaging with Barclays, JP Morgan, Citibank, and Standard Americas. Dempsey was engaging with Standard Americas, and they also had knowledge that Barclays, ABSA, and Standard Bank were involved in this conduct. And of course, then one can see that they knew that the banks were across a range of jurisdiction. They also had knowledge of the mode of implementation. Beyond their own individual participation, one can infer that they reasonably ought to have known that what they were doing was part of a broader underlying plan. Firstly, we've established the existence of a single overarching conspiracy, where the same conduct was happening at the exact same time in chat rooms and by other banks. And secondly, the core of the conduct being collusive. The nature of the communication. There are two different traders at Nomura who are having conversations with their competitors in Bloomberg chat rooms. Certainly, that can't be a coincidence. The factual allegations on the identity of the traders also show us that we can draw an inference that the Nomura traders knew that they were doing part of something bigger. There's direct communication with Howes, Katz, Aya, and Williams, who are all central participants in this conspiracy. And there was no secrecy between those traders about their connections. Nomura knew that there were multiple banks amenable to collusion, that these banks would also benefit by these strategies, that they knew that these strategies worked, and they knew that there was a platform for private conduct in which these strategies could be discussed and planned. So from the pleaded conduct viewed holistically, just certainly one could draw a reasonable probable inference that Nomura was aware or ought to have been aware of the whole scope of the conspiracy when engaged in this conduct. I will deal briefly with Commerzbank, Macquarie, and ANZ before moving on to the conduct banks. Commerzbank is alleged to have two forms of conduct giving rise to its participation in the SOC. Firstly, it employed a trader, Dowsey, who was in a chat room with Mr. Katz. You've heard his name before. And there are also conduct data examples in relation to Commerzbank. Commerzbank's conduct falls within the coordination of trading. We see RMB, which is FNB, pairs bid and ask prices with Commerzbank. We see that they manipulate the exchange rate at paragraph 231, where they initiate a focal point, and they match averages, which is the bid-ask price, with local bank Investec. And where Mr. Dowsey speaks to Mr. Katz, he voluntarily shares information with Mr. Katz about a potential customer in the market. So what would Commerzbank know from this particular conduct expressly pleaded in the referral? Firstly, they know about four of the main kinds of anti-competitive conduct, which is a substantial scope: collusion on bid-offer prices, manipulation of the exchange rate, coordination of trading, and sharing competitively sensitive information. They also know that other banks are doing the same. Dowsey knows about Mr. Katz, and they are engaging with Investec and FNB in the market. They know that it is a local and an international, well, a cartel that has members with a local presence in South Africa and international members. Commerzbank would also know that their conduct was part of a broader plan. if one looks at the facts that show the existence of a single overarching conspiracy with this precise conduct and the nature of the conduct requiring multiple participants, the facts of the identity of the traders with whom they had contact, particularly the fact that Mr. Darcy was in a chat room with Mr. Katz, who was a central player in this conspiracy and who was talking to everyone. The nature of the communication also tells us something. Mr. Darcy offers information, commercially sensitive information about customer orders to Mr. Katz. Certainly there was an expectation of quid pro quo, that he would be receiving information from Mr. Katz. And where did he think this information was coming from? So certainly we can show that there is assumed knowledge from their direct participation, because we see them in the chat rooms, we see them engaging in all the different types of conduct with multiple participants. So we can draw, certainly the tribunal at trial would be able to draw a reasonable possible inference that Commerzbank knew of the general scope of the conspiracy. The same applies to Macquarie, who is also alleged to have had a trader in a chat room. They actually had a couple of traders in a chat room with ABSA. That is at paragraph 116. So the focus of the CAC, and I'm sure my colleague for Macquarie will highlight, is that there's only one instance here. But that is not the only relevant fact that one looks at when looking about whether one can draw an inference of any knowledge or whether one can find that there ought reasonably to have been knowledge. First of all, the conduct in that chat room covers two different forms of conduct. It is both collusion on the bid-offer spread, and it is the sharing of competitively sensitive information. So it is not a once-off on a tiny aspect. It is conduct that is the core of this conspiracy. We can see then that Macquarie's traders knew about this kind of collusion, and they knew about ABSA's involvement in it. There were more than one of their traders in that chat room. And how can we infer that? What facts would give rise to a reasonable possible inference that Macquarie's traders knew that they were part of something bigger? Well, firstly, the nature of the conduct that they were engaging in requires multiple participants, and the nature of the communication. All of Macquarie's traders were there and were comfortable with this exchange that was happening. Their colleagues were exchanging information with a trader who was a competitor, and everyone was comfortable with this. It demonstrates quite clearly that this was something that happened common and that was accepted by these traders, part of something broader, and that they would then also receive similar assistance. Of course, then there is the identity of the traders with whom Macquarie's traders were colluding. Mr. Kaneni in that chat room works for ABSA, and Howe's a central player also worked for ABSA, and we also see ABSA in multiple instances in the conduct data. So together, these facts, and not just looking at one sliver of the picture, together these facts show that at the trial, once the evidence is led, the tribunal would certainly be able to draw a reasonable possible inference that this instance of conduct gave rise to, well, from this instance of conduct, the Macquarie traders either knew or they ought reasonably to have known in the circumstances that they were participating in a broader cartel. In respect of ANZ, ANZ is alleged to have employed Mr. Teasel and Mr. Katz. Mr. Katz, I don't think I need to belabor this point, has knowledge of everything. He really knows pretty much everyone in the conspiracy and has spoken to them. There are allegations about Mr. Katz's prior conduct from 2007 in the referral until just before he joined ANZ. He was employed by Standard Americas, he was employed by Barclays, and he was employed by BNP. And during his employment with all of these firms, he continued the conduct. He never stopped. He changed and he came back into the chat rooms. We see him engaging in this conduct throughout that period. And the referral pleads that traders continued their conduct even after the end of an employment relationship. So we can infer that his conduct continued, and we can infer that when Katz arrived at ANZ with all the knowledge of his activities. There's then Mr. Teasel, where there is an instance at paragraph 184. Mr. Nkotobi has dealt with that. Mr. Iyer copies and pastes a portion of a communication from a chat room that we infer exists between Mr. Madras, Mr. Teasel, and Mr. Iyer. We have pleaded that Mr. Teasel was a participant in that chat room. in a chat room. So in light of the existence of the single overarching conspiracy, that is the factual matrix in which we draw these inferences, we can see that the conduct in this instance is simply Mr. Teasel's presence in the private chat room with competing traders. He is a trader in the US dollar and rand pair. Like the other participants, he has just as much to benefit as them. He knows that JP Morgan and Citibank are using the chat rooms that are private to communicate, and he knows that they are all competitors. He is also engaging with Aya, who was a prolific member of this cartel. Mr. Teasel's, in this instance, Mr. Teasel's presence in that chat room is sufficient to draw, with Mr. Aya, is sufficient to draw the inference that he would have known the kind of conduct that was taking place in this conspiracy. Holistically, there's a reasonable possible inference that together with Mr. Katz and Mr. Teasel, ANZ had knowledge of the scope and essential characteristics of this cartel. Lastly, the two local banks, Nedbank Limited and FirstRand, and perhaps we can deal with them together because there are similarities. In respect of both of these banks, there is only one type of conduct pleaded. It is the market data conduct. There are no named traders in chat rooms. But still what we see is conduct that falls across the range of conduct that forms part of this conspiracy. In both cases, we see collusion on bid-offer spreads. For Nedbank, that's at paragraph 190.2 and 191 and 192.4. Banks matching each other and quoting identical bid-ask prices. They also coordinate their trading. Mr. Ngcobi has mentioned that the focal points, pulling and withholding trades. For Nedbank, that is 186, 235, 236, and 195. And we also see them manipulating the exchange rate. So even without a trader in a chat room, what we see is Nedbank engaging in exactly the same conduct as other participants in this cartel and participants who have a trader in a chat room. Certainly, Nedbank was aware, or ought reasonably to have been aware, of this anti-competitive conduct because it was participating in it. It also would have known the consequences. It saw what happened when other banks withheld their bids for it. It was allowed to dominate the market. It was also aware that ABSA, Investec, FirstRand, and Standard Bank are doing the same thing, and that Nedbank also knows Standard Americas is doing the same thing. They also know that these strategies would benefit them, and that they may withhold quotes today in order to allow one of their co-conspirators to benefit, and that will be a quid pro quo. They will then receive the benefit another time. So certainly Nedbank, engaging in this broad range of conduct, certainly was aware of the existence of the conspiracy, the conduct in which it was engaging with, and if one looks at the surrounding facts, the identity of the respondents, we can see that they are engaging in conduct with Standard Americas, who was the trader prolific in the chat rooms, and with ABSA, who had hired Mr. Howes. The conduct, it's also important to note when considering what Nedbank knew or ought reasonably to have known, is that the communication, there is an interaction between the chats that we see in the chat rooms and the data. We see matching of bids in the data, and we see traders discussing that in the chat rooms, for example, at 191 and 197. So in respect of Nedbank, there certainly would be a reasonable possible inference that they were aware of the essential aspects of this cartel. The same applies to FirstRand, who was involved at paragraphs 195, 230, 270.96, 234, and 232. All of these same forms of conduct FirstRand was engaging in. There is an inference that they knew about the scope beyond their own conduct, and that is because they were involved, the nature of the conduct in which they were involved in required quid pro quo, it required assistance to other traders, it required allowing other banks to benefit and then waiting for your turn. It also knew other banks were involved: HSBC, Commerce Bank, Barclays Bank, Investec, Nedbank, and Standard Bank. And they could see the consequences of their conduct in real time. They also knew that these strategies benefited them, and certainly they would benefit anyone else who wanted to adopt the same strategies. So Nedbank's knowledge covers collusive conduct, it covers multiple banks, it covers common strategies, and it covers the identity of multiple firms across the scope. So the inference there is certainly that one can draw a reasonable possible inference that Nedbank knew not only of its own conduct, but that this conduct formed part of a broader overarching scheme. And that in respect of each of the banks is the allegations within the referral, which we say from which the tribunal would certainly be able to draw the inference that all of these respondent banks, that a case has been pleaded against all of the respondent banks that meets both of the requirements in team relocations. First, that they contributed to the conduct, with the overarching objective, and second, that they did so when they knew or ought reasonably to have known that this conduct was part of a broader SOC and that they understood the general scope and essential characteristics of it.
Thank you, DCJ. Just to recap on where we are, we have addressed the conduct that amounts to an SOC. We have addressed the attribution of the conduct to the named banks. We have addressed the admissibility and probative value of economic evidence in cartel prosecutions. We have addressed the issue of authority in relation to the 3 banks that claim that not enough facts were pleaded to show that the employees alleged had authority to bind them. What we are yet to address is jurisdiction, joinder, initiation, and the so-called non-compliance with the CAC. I'm going to spend the next 20 minutes on jurisdiction, and then Ms. Zikalala will deal with joinder and initiation. Now, the topic of jurisdiction is primarily statutory. Section 3, subsection 1 of the Competition Act provides that the Act applies to all economic activity within the Republic or having an effect in the Republic. What that means is that the section is intended to address 2 things. The first thing is to address the subject matter of the jurisdiction, and that subject matter is economic activity. The second is that it is meant to address the territorial scope. On territorial scope, it addresses itself to the physical borders of South Africa within the Republic, but it also addresses itself to conduct outside of South Africa, provided that it has an effect in the Republic or within the Republic. I think that's the actual word, is within the Republic. So what this means is that it's crucial that the analytical approach that the court takes is A, work out who are the members of the SOC without considering the issue of jurisdiction. And once you know who the members of the SOC are, then work out who do we as South African courts have jurisdiction over, who is within the SOC, and then exclude those that you have no jurisdiction over. So that's the correct analytical approach. One of the fundamental problems with the judgment of the CAC is that it conflates all of these things. You just never know whether they are excluding a bank for jurisdictional reasons or excluding a bank because it was not an SOC participant. But it's crucial for this court to recast the analytical framework for logic and clarity. Now, this debate on jurisdiction is one of territory, right? Does the Act have extraterritorial application? Now, it's obvious that the Act has extraterritorial application. No one can argue that it does not have extraterritorial application. How did we get to the position where there was a finding that there is no extraterritoriality necessarily in the Act, or that it had to be established by connecting factors? We got to that because the CAC imported the common law, which requires both subject matter jurisdiction and personal jurisdiction. And the common law's requirements of personal jurisdiction comes from the old doctrine of effectiveness. You ought to be able to exercise some kind of effective control of the subject if there's a judgment. And that is where the whole idea of personal jurisdiction came from. But it was never explained why personal jurisdiction should be read into the structure of the Competition Act. In other words, why should you constrain the Competition Act with the common law? That was never explained. And we submit that there is no reason from the structure of the Act to constrain its effect by importing the common law. The Competition Act, in a sense, is a statutory delict. It's an invention of the statute to address economic activity. It's one of the few statutes that address market power. Most of the statutes we have are addressing political power. This is one of the few that is specifically designed for market power. And it knows that the markets do not respect geographies. And therefore, because the markets do not respect geographies, the legal instrument needs to match the scope of market activity. And matching the scope of market activity means do not constrain the effect of the law to the geographic boundaries. So, two people sitting in Botswana can manipulate a price of a product that is sold in South Africa. And because there is nothing to connect them to South Africa according to the CAC, we would never be able to prohibit or stop the conduct at all. Another firm could conspire in South Africa. Before they get prosecuted, they leave. And then again, our instruments are blunt. They cannot do anything about them. So there are massive consequences to the common law-centric approach of the CAC, which are inconsistent with the provisions of Section 3.1. Our learned friends have said the Act itself is constrained by this common law notion that it applies within the boundaries. And they have said so by reference to Section 26, Section 36, Section 59, and Section 64 of the Act. None of which actually show that the jurisdiction of the tribunal is not extraterritorial. Section 26 simply says that the jurisdiction of the tribunal is throughout the Republic, which means it's not limited to the province where it's located. It's throughout the Republic. It has nothing to do with extraterritoriality. Section 36 is simply the same provision applicable to the Competition Appeal Court, meaning that they have national jurisdiction. They are not constrained to provinces as the High Court is constrained. Section 59 is a method of calculating administrative penalties, which says that when you are going to impose a fine, you may not exceed 10% of turnover in the Republic. But that again does not mean other remedies may not be imposed, which are not about the calculation of a fine. Declaratory orders, interdicts, mandamus, all of those orders are permitted within the scope of the Competition Act, and the tribunal can give them. Section 64 simply says that the orders of the tribunal have the same standing as the order of the High Court. Again, nothing to do with limiting the extraterritorial scope of the Act. So we come back then to where we started on this topic. The clear language of Section 3, subsection 1, is extraterritorial. Otherwise, it makes nonsense to have that disjunctive or after within the Republic. makes no sense. It's clearly an extraterritorial statute. Number two, even when read in the context of the statute as a whole, because the primary purpose of the cartel provisions in the Act is the protection of the consumer. Others will say it's a protection of competition. All right, fine. But I submit that the primary purpose is the protection of the consumer from prices that are a product not of competition, but are a product of fixing or allocation or collusive tendering. That object is defeated by a common law-centric approach to jurisdiction. And then the purpose of it, the purpose behind Section 3.1 is clearly to widen the reach of competition authorities. Why? Because it is a statute that regulates market power. And market power, by definition, is not constrained to geographic boundaries. So if you apply cool ideas, the three levels of interpretation, text, context, purpose, it's clear that we have an extraterritorial statute. And it's clear that there is no reason to limit the scope of this act by superimposing the common law. So we ask that you remove those constraints that were imposed in 2020, that were confirmed in 2023 by the Competition Appeal Court, and give the statute the plain meaning that was intended by the drafters. The only question, therefore, would be whether the pleading shows effects in order then to bring the conduct within the jurisdiction of the Competition Tribunal. It is replete, and I use the word guardedly, the pleading is replete with instances of effects. Let me just highlight 4. The pleading makes a connection between the collusion on the bid and ask spreads with the volatility of the currency. This is illustrated in paragraphs like 270.31 and 270.93 and 270.94, which is the consequences of weakening the rand. You know, Deputy Chief Justice, many years ago, when this case started, 2017, there was a lot of skepticism about the very idea that the currency could be subject to manipulation by traders. That skepticism has now been disproved completely by the evidence. In Australia, people have been arrested, sent to prison. In America, people have been arrested, sent to prison. In Europe, for this. It is only this jurisdiction that is yet to apply effective sanctions against this conduct. Number 2, the manipulation has effects on dollar-denominated products, primarily imports and exports, and these could be substantial. Look at paragraph 270.4, which then aggregates the amounts of these products between 2004 and 2014 at $2 trillion. Number 3, the price manipulation has a permanent effect in changing the structure of the market. So even if today you buy a dollar that is not the product of manipulation, that dollar's price is still influenced by previous manipulation. So what it does, it introduces a permanent structural change to the value of the currency. Number 4, even ordinary consumers were affected because the distortion affects the value of the products. Products that are imported that you find in the shop, or products that come as a result of a combination of imports and exports that you buy in the shop. So ordinary consumers who see the things they buy, the shoes they wear, the clothes that they wear, those are impacted because the currency has been manipulated. So it's clear that there is an impact in South Africa as pleaded, at least on a prima facie basis. And so, because the pleading demonstrates effects, there would be jurisdiction over that conduct if it is economic activity. That's actually the simple structure of the Act. And so what that means is that there is no jurisprudential reason for a debate on what the effect of the common law is. Our learned friends are saying, no, you never raised, I don't understand the argument, you never raised this issue before the CAC, etc. We did. It was right in the pleading. The pleading expressly says that the jurisdiction is founded on Section 3.1. Even in the oral argument we raised, what happened is that Judge Davis, who was presiding, shut us down from raising the argument. But we raised it. You can look at the record, you'll find it, it's there. But it's irrelevant whether we raised it or not. It's a matter of law. This court needs to correct the law so that it's clear that jurisdiction is established by reference to Section 3.1 and not by reference to the common law. Now, if we are wrong on this, and that you have to look at connecting factors, which are a common law requirement, because they come from the judgment of Strang, judgment of Judge Howie, paragraph 56, who then develops the common law and says, well, we need these connecting factors if we are going to apply extraterritorially. The problem is this, justices. The CIC still misunderstood even that test. The test comes from paragraph 56, and if I could, yes, I still have some time. If I could just read it, the test is paragraph 56 of Strang. In my view, it would suffice to empower the court to take cognizance of the suit if the defendant was served with the summons while in South Africa, and in addition, there was an adequate connection between the suit and the area of jurisdiction of the South African court concerned from the point of view of appropriateness and convenience of it being decided by that court. If you recall, in paragraph 85 of the judgment of the CAC, it confuses the test because it says the test is whether there is a connection between the foreign banks and the South African banks. Now, that is just a misreading of the test. The test is whether there is a connection between the suit, the conduct, and the area of jurisdiction. In other words, the conduct in South Africa. Is there a connection between the conduct and South Africa, the place of jurisdiction? Now, that error committed in paragraph 85 of the judgment is taken up by a lot of our colleagues. They perpetuate the error, that the question is whether there is a connection between the foreign banks and South African banks, or that there is an adequate connecting factors between that conduct and South African banks. But that's just not the question. The question is connection between the suit as well as the area of jurisdiction. And the lens you take in order to draw that analysis is the lens of appropriateness and convenience. You are trying to ask a very simple question. Where is it most appropriate and convenient to prosecute a cartel which involves the manipulation of the rand? The Americans have prosecuted and sent to jail Cummins, Katz, Ayer, all of those guys. They will never come to South Africa and do this job for us. It's only the South African institutions that will prosecute the people who manipulated their own currency. The currency is the sovereignty of the nation. So if you are to ask then whether there is sufficient connection between the suit and South Africa, which is the correct question that must be asked according to Judge Howie, what are the factors that we say you should take into account? Again, this is not our brilliance. Most of this work has been done by the Competition Tribunal. It listed 4 facts that we commend. Firstly, it's the fact that it's the rand. So what is the place that is most appropriate to decide a case about manipulation of the rand? Right? When we raised this issue at the CAC, we were literally shut down because the judge said that is about subject matter. There's no scope for debate. I've said it. But he was wrong. The rand is the glue that keeps the SOC together. And if you are going to ask what is the best place to judge a case about the manipulation of the rand, only South Africa can, because this is the signal of our sovereignty. Number two, the overwhelming majority of the banks are actually banks with South African connections. They are South African banks, but even the other banks that are not South African, there are still two categories of those peregrine, those that trade in currency or carry out the business of a bank in South Africa, or those that have a representative office in South Africa. In fact, only a minority of these banks are pure peregrine. Only a minority are pure peregrine. The majority are banks with South African connection, either with a representative office or a trading branch or an office that conducts the business of a bank, or purely South African. Number three, the fact that there is no other forum, and this is a factor the tribunal took into account, there is no other forum that is prosecuting the manipulation of the rand. The reason Cummings is in prison is because he manipulated the dollar. No one cares about the rand except South Africans. So the fact that you are ultimately being asked to promote impunity, because if you find that I cannot prosecute these people, they cannot be prosecuted anywhere. And one of the factors you will take into account in exercising these so-called connecting factors is the need to avoid impunity. Number four, and again this is a factor the tribunal took into account, is the fact that the central allegation is that there was a violation of South African laws. The reason Cummings was sent to jail is because he violated antitrust provisions of America, not because he violated the South African Competition Act. Only this court, the CAC, and the tribunal can adjudicate the question whether South African laws were violated. All of these factors show overwhelmingly that South Africa is the most logical jurisdiction to prosecute the matter. It shows a connection between the suit and the place, which is the true question to be asked under paragraph 56 of the judgment of Strang. Deputy Chief Justice, I need to give Ms. Zikalala to address the two topics on initiation and joinder. There is one small topic, which is the alleged non-compliance with the CAC order that I have not addressed. If there is no time by the time she finishes, I will address it in question time. Yes,
it's at uninterrupted time.
Yes, she might take all of it. I don't know, but I don't want to stop her.
She understands that will be to your client's peril.
I'm not sure if it will be to our peril. What she will be addressing...
In terms of not being able to address us,
yes,
on the point you want to raise.
Yes, that's the only point. But what she has to address is crucial for the case, and not as crucial as my point.
Thank you.
Deputy Chief Justice, Justices, as Mr. Ngai-Toby has said, I will be addressing you on the issue of joinder and as well as the issue of initiation. Deputy Chief Justice, Justices, you will have seen from the judgment of the CAC that from paragraph 183 to 186, it sets out its findings in relation to the reasons why it has released certain banks. And at paragraph 184 of the CAC's judgment, it finds that in respect of three respondents in particular, Nedbank, First Rand, who's also RMB, and Standard Americas, that the tribunal had acted in breach of the CAC's 2020 order in joining them to the referral, and therefore their applications to set aside their joinders must succeed. Just as an important point of juncture that I'd like to be able to point out is that in relation to First Rand Bank, it in fact did not oppose its joinder as a respondent. There was no application before the CAC in the appeal to set aside as it sought to do in paragraph 184. For my framework of analysis on the joinder issue, I have relied primarily on this court's judgment in SOS, where this court considered an order of the CAC to preclude, in that case, the Competition Commission from exercising its statutory authority functions in respect to an investigation. This court set out the following framework in its analysis. Firstly, the court considered the legal context, as this court has held in Moise. The proper interpretation of a court order also includes the legal context within which the order is made. The second is the court looked at what is the manifest purpose or object of the order, primarily looking at its language and in accordance with the usual rules of interpretation, relying on cases like Eek versus Parsons and Firestone. And the third that the court used in its analysis was to consider that when one is dealing with a statutory function of the commission or the tribunal, one must consider whether the order contains an express prohibition or express language to indicate that it sought to restrain the exercise of that statutory function. In respect of the legal context, justices, a decision to join parties to proceedings like the power to substitute parties or consolidate actions is a procedural mechanism intended to prevent the multiplicity of actions, conserve judicial resources and legal costs. Joinder forms part of the power to regulate proceedings, and it is a power that has been traditionally enjoyed by courts emanating from the common law. However, in respect of the tribunal, the power to regulate its proceedings in this manner emanates from the Act itself. In terms of Section 27 of the Act, which deals with the functions of the competition tribunal, the tribunal must consider and adjudicate on any conduct that is prohibited. In the performance of this adjudicative function, the tribunal is empowered to make any ruling or order necessary or incidental to its functions. That is in terms of Section 27(1)(d). Thus, we would submit that the ability to make any order necessary or incidental to the functions of the tribunal in terms of Section 27(1)(d) is wide enough to include an order to join parties. However, in addition to that, the tribunal has published rules in terms of Section 27(2), which include expressly the power to join parties in Tribunal Rule 45. Over and above that, when dealing with the rules of procedure, the Act provides that in Section 55(1), there's a residual procedural discretion given to the presiding member to determine matters of procedure. Justices, what emerges from a reading of these sections of the Act is that Parliament intended, 1, to give the tribunal in the execution of its adjudicative functions the power to make necessary and incidental orders, including the power to join parties. 2, the Act itself intended to provide the tribunal with the discretion in relations of matters of its procedure. And 3, and this one can see from Section 55(2), the Act imposes a duty on the tribunal when running its proceedings to run those proceedings with expedition, informality, and in accordance with the rules of natural justice. This is why the tribunal, when it considered the 2020 CAC order, asked itself this question when considering its statutory framework, whether the 2020 order would amount to a fettering of its discretion to order appropriate remedies in these types of proceedings. The tribunal correctly concluded that the 2020 order cannot be interpreted to fetter its statutory functions, powers, and obligations to regulate its proceedings and to make appropriate orders, particularly because these were still preliminary exception proceedings, which had not proceeded to the merits. And in addition, the order could not be interpreted to compel a future panel to come to a predetermined outcome in respect of matters of procedure which sat before it. In relation to the manifest purpose, Justices, I had intended to look specifically at the order. I would ask Justices if you could pull up volume 1 and 2 of the record if you have it before you. Justices, the CAC in paragraph 37 of its judgment considered the implications of its 2020 order and determined that the implications of its order were that the Commission was required to redraft the referral, 1, and 2, it finds, secondly, that the Commission and the Tribunal had not been intended that new parties could be added. So it finds two things. One is that the Commission was required to essentially reorganize and streamline its referral, and 2, that there was no intention that new parties could be added. However, what we see from the case law is that when interpreting a court order, this is an objective exercise that one does looking at the order itself and the language, and not necessarily a subjective exercise. And so what we must do is determine whether when looking at the order itself, one can see that very purpose. Justices, might I ask you to turn to volume 2, page 113, which is the beginning of the CAC's 2020 order, in the main page 114. And might I ask you also in relation to volume 1 to turn to page 74. Just by way of context, in 2019, when the first tribunal decision was made, the tribunal had concluded that it did not have jurisdiction over the Pure Peregrini, and therefore dismissed the referral as against the Pure Peregrini banks, but put in place an order requiring the pleading of the SOC, the single overarching conspiracy, in respect of the local Peregrini and the Inkala banks. So the first tribunal decision said the Pure Peregrini were, the referrals dismissed as against them, but the requirements for pleading the SOC and pleading particularly subject matter jurisdiction were made specifically for the local Peregrini and Inkala banks. On appeal, the CAC overturned the decision on jurisdiction and thus retained the Peregrini banks in the referral. This is evident from paragraph 1 of the order, which is on page 114, volume 2, where the CAC upholds the Commission's appeal in respect of the tribunal's decision to dismiss the referral as against the Peregrini banks. The CAC went further then. Because the Pure Peregrini banks were now back in the referral, the previous requirements that had been made by the tribunal regarding the pleading of the SOC and as well as subject matter jurisdiction had to also be extended to the pure Peregrini who were previously excluded but are now included by the CAC. The CAC does this at paragraph 3.2 of its order. And in particular, Justices, one must look at 3.2.1 of the CAC's order as against 3.4.1 of the tribunal's order that's in volume 1, page 74. Justices, what you will see from comparing those two orders is that the order of the tribunal is imported in identical terms into the order of the CAC, save for one change. In the opening line of the CAC's order at 3.2.1, it says in it, or rather, let me put it this way. In the tribunal's order, in the opening line in respect of subject matter jurisdiction at 3.4.1, the requirements were made specifically to local Peregrini. When the CAC imports that order into its order, it now makes those requirements to apply to all the named respondents. It therefore makes that change. It changes the part of the tribunal's order that applied only to local Peregrini and changes that and says it must apply to all the named respondents. Thus, when you're looking at or trying to determine what was the manifest purpose of the CAC's order, it was, as one can see from paragraph 3.3.1, to require the Commission to streamline its affidavits. That is correct. And in respect of that part, we would agree with the way it was formulated by the CAC. However, the second intention was for the CAC to extend the pleading requirements that had previously been limited to also now include the pure Peregrini. That is the magic in the use of the words named respondents. The banks that take the point that no future respondents were supposed to be joined after the 2020 order cling to the use of the words named respondents in paragraph 3.2.1 of the CAC's order and paragraph 3.3.1 of the CAC's order. But the entire purpose of using the words named respondent was to extend the pleading requirements that had been set by the tribunal to include also the pure Peregrini. Thus, in relation to the last requirement that we had seen from the SOS judgment is that when one looks at the CAC's order as a whole, there is nothing in the language of the order, and there is nothing in the language of the judgment as well that indicates that there was an intention to exclude the power to be able to join parties in future. There's no express prohibition. There is nothing to indicate that the Commission and the Tribunal would in future be precluded from bringing an application and considering an application for joinder of parties. So, Justices, we would say that the Tribunal correctly exercised its discretion to join the 25th respondent, the 27th respondent, Nedbank, FirstRand, and Standard Americas. Had the CAC moved beyond whether there was a breach of its order and considered whether the exercise of the tribunal's discretion was done so appropriately, it would have considered factors such as that no other forum has jurisdiction over Nedbank, FirstRand, and Standard Americas in relation to foreign exchange price fixing and market division in contravention of Section 41B of the Act. If the 2020 order is interpreted to preclude the power of the tribunal to join these parties, the Commission would have to bring standalone proceedings for these three respondents in circumstances where it was clearly convenient and appropriate to join them at this stage of proceedings. These parties received the 2020 referral at the same time as the other parties. None of the other respondents have pleaded to the merits of the matter. Like the other respondents, they have brought exception and dismissals applications. In fact, no benefit can be gained by requiring either the Commission or the Tribunal to have to run standalone proceedings in respect of these respondents, creating a multiplicity of actions and thereby overriding the statutory injunction on the Tribunal to run its proceedings with expedition and informality. Given that this litigation has not moved beyond procedural objections, notwithstanding the many years that have passed, whether there was, for example, a delay to have joined a party like Standard Americas, must be weighed against the fact that it admits to having employed, as the justices you've heard, the chief architect of the conspiracy, Jason Katz, for between 2001 and 2010. It also employed Freeman. And whereas in relation to BNP, which was retained in these proceedings, the CAC finds that its employment of Katz placed a burden on BNP to explain the conduct that is alleged in the referral. The CAC does not consider this in relation to its release of Standard Americas. Justices, we would say that the CAC committed an error of law when it found that the tribunal was precluded by its earlier order from joining new respondents. It failed to consider the legal context within which the order was made. There is no express prohibition, and therefore there was no basis to interfere with the tribunal's order. I now turn to the issue of initiation. Justices, the more confusing part of the CAC's decision of the two topics that I have to deal with is what it found on the issue of initiation. Again, in paragraph 183 and 188 of the CAC's judgment, it seeks to summarize the basis on which it released or retained certain banks. If one looks at the findings of the CAC, there is no single bank that is released on the basis that the complaint has not been initiated against them. Not one. This confusion is exacerbated by the fact that the CAC briefly deals with the issue of initiation, but only in relation to Standard Americas, when initiation is raised also by Nedbank and as well as CSS. As my learned leader has indicated, the CAC doesn't even deal with Nedbank at all in its judgment. And in relation to CSS, it is retained in the proceedings. So whether it considered and to what extent it concluded on the issue of initiation is unclear because it has retained CSS in these proceedings. It has, frankly, been difficult to decipher what the eventual conclusions were of the CAC. However, I seek to summarize the Commission's central arguments on the issue of initiation. First, the Commission's case in respect of initiation begins, as it should, on the clear and unambiguous wording of Section 49B(1) of the Act, which provides that the Commissioner may initiate a complaint against an alleged prohibited practice. The Act requires initiation against the prohibited practice being the conduct, not a particular firm or party. As this court stated in Pickford, the emphasis in those provisions in Section 49B is on the prohibited practice concerned, not the firms or parties implicated in it. Just going to what is the purpose of initiation. The Act requires initiation to trigger the processes in terms of the Act. As this court observed in Pickford, there is no definition of the term to initiate or initiation in the Act. It merely is there to trigger the processes of the Act to include investigations and which could ultimately lead to the referral. The second purpose of initiation is that it triggers the time bar under Section 67(1) of the Act. Initiation is a jurisdictional requirement for a referral. However, and this is important to note and to make clear, initiation is not a form of notice. It does not affect a respondent's rights. A party is not affected by it, and this was found by the Supreme Court of Appeals in Yara. Initiation is not notice. Now, with regards to whether firms need to be explicitly named in the initiation statement, the facts of Pickford are particularly instructive in this regard. Pickford's, this court's decision in Pickford's, concerned a case of collusive tendering in the furniture removal industry. The case against Pickford involved two initiations. A first initiation and an amended one. The first initiation of 2010 initiated against the conduct, but Pickford's name was not specifically added to that conduct. There was an amendment to the initiation, and in the amendment to the initiation, Pickford's name was explicitly included. The question that was before this court concerned when is the correct trigger date for Section 67(1) time bar. Is it 2010 when Pickford wasn't explicitly named? Or is it 2011 when Pickford was specifically named? That, in fact, was the difference between the CAC's judgment in Pickford's and this court's judgment in Pickford's. The earlier decision of the CAC in Pickford's, which was overturned by this court on appeal, found that because Pickford's was only specifically named in 2011, i.e. the later one, the prohibited practice did not involve it. That's the decision that this court overturned in its decision. Because this court found that that approach that required that not only that you initiate against the conduct, but as well as the specific name, that is when the Section 67(1) time bar begins to run, that this misconceives the purposes and objects of the provisions relating to initiation in the Act. So in Pickford, this court found that the correct trigger date is the date for initiation of the this court found that the correct trigger date for the initiation of a prohibited practice was the earlier date, the 2010 one, even though Pickford was not explicitly named in that initiation statement. So in other words, this court found that the processes of the Act were validly commenced as against Pickford's, even though at that initiation statement it was not explicitly there. We say then the following 5 principles emerge in regard to initiation. The first is that you initiate against the conduct, not the firm, as this court's already observed. Even though, as our learned colleagues say, well, there can be no conduct without firms, this court heard that argument in Pickford's and answered it specifically in Pickford's when it said that notwithstanding that you can't have conduct without the firms, it doesn't change the emphasis of section 49B1 to being about conduct and not the specific names of firms. Second, initiating against the conduct includes initiating against all the parties who are said to be involved in that conduct. This is clear from the facts of Pickford's and the difference between the 2010 and 2011 initiation. Third, the date of a valid complaint initiation for purposes of section 67(1) is the date on which the conduct was initiated against, not the date when the name of a specific firm is added either in the initiation documents or joined in the referral. Fourth, in determining whether there is a valid complaint, whether there's been a valid initiation against conduct, the question a court must ask when determining this is the Commission accusing Nedbank, Standard America's, CSS of substantially the same conduct that it initially initiated against on 1 April 2015? If the answer to that question is yes, there is a valid initiation as against conduct. Notably, and I place some emphasis on this, none, not one of the 3 banks that raise initiation as an issue allege that they are being accused of conduct that is different to that which the Commission has already initiated against. They don't take issue with the conduct that they are being added to. They simply want to see their names there. 6, if the firm is being added to substantially the same conduct against which there is a valid initiation, then the Commission has met the jurisdictional requirement of section 49B. The jurisdictional requirement has been met. The tribunal now has jurisdiction to be and may be able to exercise its powers over those parties. Thus, if one can say that the CAC determined the issue of initiation, we would say that the CAC simply asked itself the wrong question and answered the wrong question. In the facts of this case, the relevant question was not whether a referral could be made without initiation against a firm, because initiation is against conduct, not a firm. And secondly, in respect of all the parties in this litigation, there has been a valid initiation. There is no firm that is being accused of conduct that is different from that which was described in the April initiation. There is therefore no reason why the tribunal should not have jurisdiction over that respondent. It is, we would say, simply illogical and irrational to suggest that the Commissioner sought to initiate a complaint concerning widespread currency price fixing and market division against some banks, but not others that were involved in the self-same conduct. It would equally be irrational and indeed promote impunity to say, as the tribunal pointed out, that the Commission is precluded from adding these respondents, even if it turns out that some of them are self-confessed cartelists, or where their involvement comes to light because of, let's say, discovery processes. In the circumstances, Justices, we would submit that if one considers this court's decision in Pickford, and if one considers the act on its wording, it is clear that there's a valid complaint initiation as against all parties, and therefore that this objection, to the extent that it remains an objection, should not be upheld. Justices, I've left my learned leader with 35 seconds.
Deputy Chief Justice, when an address has been good, you shouldn't spoil it by trying to speak. Most of what Ms. Zigalala said about the interpretation of the judgment in relation to joinder applies to the address about whether the exception should have been upheld because it allegedly did not comply with the order. So on that basis, I will align myself with what she said. Thank you. Yes, as long as you just explain whether they are directed at me, Ms. Zigalala, or Ms. Hopton. Yes, I'll pass around the responsibility if they are too difficult.
You said the CAC committed an error of law
Yes,
in the interpretation of Section 3.1.
yes.
And whatever interpretation that it made in 2020, this was endorsed in 2024 in its second judgment. Your colleagues representing the banks say that you cannot ask this court to interpret Section 3.1 because that is an issue that you should have raised or appealed on way back after the 2020 judgment. So, and that therefore, if you have not done that, the issue of preemption comes into play. I'd like you to address us on that, explain why we should conduct an exercise of interpreting Section 3.1 as you seek today.
Well, Justice Mhlanga, it's not today. It's in the application for leave to appeal and in the heads. But let me start with the referral affidavit itself. So it is in volume 5. So the page 387. Paragraph 42. So that was the pleading. The pleading relied on Section 3.1 and as interpreted there. And you can see that that's a simple interpretation of the section, which is economic activity having an effect. Then that's in relation to the pure incola. Then you go to the first class Peregrini, page 388, paragraph 45. Now again, you have the same language there that is used. Pure section 3.1. The second class, paragraph 48, page 390. And then page 391, paragraph 51, in relation to the pure Peregrini. So the pleading before the tribunal and before the CAC has been consistent with the arguments I am making today, which is there is jurisdiction because the economic activity complained of has an effect in South Africa. So that has never changed. This is not a new case. Now, you then get into the Competition Appeal Court in the argument. I specifically raised there that the correct construct of Section 3.1 is a construct that's divested of the common law constraints. The judge has obviously dismissed that. Justice Dennis Davis refused to entertain the argument, and then he obviously dismissed it. So I'm entitled now to say, before the Constitutional Court, my pleading was correct. The jurisdiction of the tribunal was established as alleged at paragraph 51 in relation to Pure Peregrine, 48, 41 in relation to the Incola and the local Peregrine, which is just a straightforward interpretation of Section 3.1. So there can be no question that they had no notice. They knew, because that's the case we ran from the beginning.
No, I'm not talking about notice. My understanding of the respondent's argument is that once the CAC won, rejected your argument and came up with its own interpretation, which you do not agree with.
Yes.
You should have appealed, but you did not do so. And now, before this court,
yes,
you are now rising at that point.
Yes.
And I think that's what I'm trying to understand from you.
Yes.
And they say you can't do so now and ask us to then interpret that section.
Yes. All right. Well, and I understand.
Go further and say, in fact, what the commission did was to then try and comply with the order of the CAC1 and then prepare the referral and the affidavit that was filed subsequent to that judgment.
Yes. Yes. On that second question, I've just shown that the referral sources jurisdiction from Section 3.1. It's expressed in relation to all of the respondents. So on that second question. Then on the first question, should we have appealed or not? There can be no requirement that we should have appealed the 2020 order, which was midstream. It was an order to tell us to plead the case. And it was in a midstream, which we did. But this is a question of jurisdiction. It's a question of law, pure question of law. Even if it was not this case, it had been a different case decided by the Competition Appeal Court. We were always entitled to say the correct interpretation of the Act is X. There was no reason for us to first appeal that judgment in order for us to advance the argument before this court that the correct interpretation of Section 3 is that there is jurisdiction. This is a section on jurisdiction. So it's either there was jurisdiction or there was no jurisdiction as per the provisions of Section 3.1. So the fact that we did not appeal the 2020 order is clearly not fatal, because if it was wrong then, it's wrong now, and the best place to correct it is here. And especially, and that's a further point, Justice Mhlanga, especially because we now see how they apply it. We see the actual consequences of applying it. It's one thing to have an order in the abstract. It's another to see what it means when it's put into operation. And it's only now that we see how they put it into operation. Then it's clear that they've misinterpreted Section 3.1. You have to either agree with us or disagree with us about whether Section 3.1 is constrained by the common law or not. But you have to make that judgment yourselves.
Agree with me that when you disagree with a court's order, one would ordinarily appeal that. But you say in this particular case, that was not necessary because this was done during the exception stage.
Yes. But I also say that it's a jurisdictional question. We are either wrong or right on that issue. The tribunal either has power or it has no power, and that's a question of construction of the Act. And we never considered it. I mean, our referral is clear that we've always said it's Section 3.1 that governs, as interpreted in the way that I've tried to run here.
When it comes to the exception...
And sorry, Justice Mhlanga, that answers the preemption point because preemption is a fact-based inquiry.
Thank you. Coming to the actual exceptions, if we are with you, that the exceptions are not vague and embarrassing as the respondent banks are saying, what is the next step insofar as the matter is concerned? Is there another affidavit that will be filed, or will the matter go to trial on the merits? I'm trying to understand them when they seem to seek more particulars on what is pleaded by the Commission.
I think the best is to look at the order of the CAC in relation to the 4 banks that it found were within the ambit of the SOC, which is at volume 3, page 299. So paragraph 3 says BNP, JP Morgan, Credit Suisse, and HSBC, those applications are dismissed. In other words, their exception applications are dismissed. And then paragraph 4, it then says the respondents listed under paragraph 3 must file their answering affidavits to the referral within 40 days of the order of this court. So I would imagine that what will happen is simply an extension of that order to the excluded respondents.
Will be entitled to file a reply.
I'm not sure in these referral proceedings because I think I'll check whether we have to file a replying affidavit. But I think at a certain point in time, we must do discovery and a pre-trial conference, and then the matter must be set down on trial. But that also depends. There's another variable, which is whether they don't take special pleas on some other technical point, and that special plea also making its way up until the Constitutional Court. But ordinarily, if they file answering affidavits on the merits, I think the next step will then be discovery, pre-trial conferences, and then witness statements, and then trial.
Thank you. Advocate Gugatobi, do I understand you to be saying, if we are with you on this argument, and I think riding on the question of Justice Nhlanhla here, the matter goes to what we call the trial stage, and
Yes.
everything that happens there.
Yes, yes.
Thank
I think that's the correct formulation.
Thank you very much.
Mr. Ngugatobi, in a way, my question is related to what you debated with Justice Mhlantla, but it's not about jurisdiction. It's about the terms of the order of the Commission. In your argument, let me just confirm first whether I heard you correctly. I heard you to be saying that it is not necessary for the Commission to prove that each bank participated and knew every facet of the SOC.
Yes, in order to be in the SOC. Yes.
Then I looked at the order of the CAC. Now we're looking at CAC 1. CAC 1 is the one that is case number 175, CAC July 2019.
I just want the volume so that I'm looking at. Yes, Justice Patrick, I'm listening.
Paragraph 3.2.5 says that you should provide each respondent with a date or period in which they are alleged to have joined the SOC or deemed to have joined the SOC, each respondent.
Yes.
And then it also says that that is now 3.2.6, provide the facts that are relied on to prove that the particular respondent joined or had joined the SOC. It seems to want you to be specific concerning the particular respondents.
No, we say that we did that. What I'm saying is that on the test for an SOC, the law is that in order to attribute conduct it is not required that you must have participated in every form. So there are 5 instances of conduct. So Bank A could have participated in 2 and not 3. What the CAC wants us to do is to specify which of those 2 we say they participated in. Yes, and it also wants us to specify when they joined, which we've done.
Okay, so you satisfy that you complied with the order?
No, we've complied with the order. Insofar, the only aspect in the judgment of the CAC where there is a criticism on this is what Ms. Zikalala addressed, which is the question of joinder of new parties, because it says you should have confined yourself to the named respondents, and so we've debated that. But where the parties, for instance, the banks were saying, before the CAC were saying, no, you've got another problem because you have not specified the end date. That was answered in relation to the banks that were retained. The CAC found that that was not a fatal error because there was no prejudice suffered by the banks, because what the commission said, it gave you the bank, it gave you the date when we say, we assume you joined it because we saw you participating. And then it gave you the date that was known as of the termination, which was 2013, but it also contained an alternative and said, we cannot say that it ended in 2013. It could have continued, but because this end date is linked to Section 67 and they bear the onus on Section 67, they must then explain from their perspective, because the end date in judgments like Crossfire of the CAC is the date when the last benefits of the cartel conduct stop flowing. And that's typical information no authority has when it initiates proceedings. It's information that resides squarely with the respondents.
Thanks. Thanks, Mrs. Jane.
Mr. Ngugaitobi, I'm trying to understand what the applicant is saying in respect of jurisdiction as it relates to Section 3.1 of the Competition Act and to the common law. Is the applicant saying that there is no need to establish the common law grounds of subject matter and personal jurisdiction if the requirements in Section 3.1 are met?
Yes.
Now, Section 3.1 speaks to subject matter jurisdiction and is silent on personal jurisdiction.
We don't accept that interpretation about the scope of Section 3.1, because what we say Section 3.1 deals with is the subject matter, which is economic activity, and the territory, which is within the Republic or outside of the Republic. It deals with both of them.
Are you saying that Section 3.1 is an exception to the common law?
No, it's not an exception to the common law. The Competition Act created new forms of prohibited economic activities. And those were not based on the common law at all. They were simply invented by the statute. So it's a self-contained piece of legislation.
And on the applicant's argument, there's no need to develop the common law in relation to personal jurisdiction.
Precisely. We say that apply the section as it is.
Now, the underlying rationale for the requirement of personal jurisdiction is effectiveness.
Yes, I accept that.
So that courts are able to enforce their orders and not just make orders that would be toothless.
Yes, no, I accept that entirely.
If we are with you in respect of your argument in Section 3.1 and it gives the Competition Commission or the tribunal a jurisdiction, how would those orders be enforced?
Yes, well, the tribunal actually has a much more, I would say, enlightened answer to that question. So first, you've got to look at the range of remedies that the tribunal has, which include declaratory orders, which include interdicts, which include structural remedies, you can call it like that, structural remedies. And of course, in some instances, they include penalties. It has been found many times that a declaratory order is in fact an effective remedy because it declares the rights and obligations of the parties. So insofar as we don't have your annual turnover in the last year of the, I think Section 59, in the last year of the cartel behavior, we don't have your last turnover. That does not mean there are no effective remedies, because there's a range of other remedies. Some of these parties may want to come to South Africa, and in fact, the majority are in South Africa. They have got presence in South Africa, overwhelming majority. We're talking about a tiny minority that is pure, external. But because you have a range of remedies that are not limited to penalties for financial payments, the other remedies that remain are also effective remedies.
Would they be effective against respondents who are not based in South Africa at all?
Indeed, especially because of the cross-pollination of the forces of commerce. If a finding is made in South Africa that BNP Paribas conspired to fix the rand, that finding is a very strong moral judgment which impacts on it in whichever jurisdiction it finds itself. Every market activity that it conducts itself will always be judged against that in one jurisdiction it was found to have conspired to manipulate the currency.
Now, do I understand the Competition Commission to advocate for an unqualified effects test as opposed to a qualified effects test?
Yes, we rely on ANZAC for that, yes.
Now, if this court has to interpret effect liberally with no qualification, would that not cast the net too wide and give the tribunal jurisdiction over any economic activity with any effect on the South African market? And is that how we must read Section 3.1, or have the effect of Section 3.1?
Yes, I suppose, Justice Teron, in every case, there will be a need, like in this case, we've pleaded fully what the effect is, and this is substantial effect. So this is, on the facts of this case, it's substantial effect. But there may be another case where perhaps a defense of de minimis will mean that there is no effect at all, you know. Because in interpreting effect, you have to take sort of a robust common sense approach. You know. So a court or a tribunal will be able to say, this is so small that we cannot even regard it to have been effects as contemplated by Section 3.1 in order to claw that with jurisdiction. But I think what we are trying to say, and maybe if I can recast it a little bit, is to say that the European qualified effects test and the American qualified effects test is not what our Section 3.1 has in mind. The Americans wrote it in their own guidelines. That's where it comes from. We don't have it in our statute. But I would accept that a de minimis could be a defense, but that would simply mean there are no effects.
If we're not with you in your primary argument that Section 3.1 is an exception to the common law, then would we have to consider a development of the common law in relation to personal jurisdiction?
Yes, that is the debate we've had with the CAC since 2020. And we would ask you to adopt a line on the development of the common law, a line that is not what the CAC did in 2024.
And if we have to develop the common law, should we adopt the adequate connecting factors development in relation to competition law only, or should we consider a more expansive approach?
Well, what we have said, I mean, I suppose, first there's a problem with what Judge Davis did in the CAC, because he asked the wrong question on this adequate connecting factors test. Okay. But here the question that would have to be asked then is whether there are adequate connecting factors between the conduct, which is the conduct described in Section 41B, and South Africa, the place of the litigation.
And confined to competition law, or I want to push you to continue.
Yes, I know, that's the question you asked, and I try to avoid it, but I'm not succeeding. I think that, Justice Teron, the problem is that our development is because it's also informed by Section 3.1, which is a statute, because the development we argue is a development that is required by Section 3.1, which we say is an extraterritorial provision. But in Strang, there was no statute in issue. It was the general development of the common law, which the court has not yet pronounced upon. So if you are developing Strang, then it will be of general application. But I'm here on a competition case, and I'm trying to sort of bet for my team.
My final question to you, Mr. Ngaitopi, relates to the single overarching conspiracy. In the Commission's founding affidavit, it is alleged that the Competition Appeal Court erred in its application of the law in that it found that the referral affidavit was not sufficiently clear to show each bank's participation in the conspiracy. Does this question engage this court's jurisdiction?
No, because if it's a pure factual analysis, no. But what we've also tried to show, hopefully in the heads and in the argument today, is that it's also a legal question, because it's the correct interpretation of the referral affidavit. And the question as to whether you are inside or outside is not a pure question of fact. It's also
How
a mixed
does it
question.
become a legal question?
Well, the question whether you are in or out, you must first answer a legal question of conduct and attribution. And then you can apply that on the facts of each case.
Isn't conduct a factual question?
Yes, but you have to, yes, it is. It is when it is applied. But I think the point I'm trying to make is this. The conduct is the breach of the section. So if you adopt the test that we are proposing, because the court has not yet adopted an SOC. So if you adopt the test of an SOC, which is conduct plus attribution, that's a legal question which we've been trying to suggest this morning. There is a secondary question as to whether those who were excluded for the correct legal reasons. Now, when you look at those who were excluded, we say they were not excluded for the correct legal reasons. They were excluded for incorrect legal reasons.
Yes. Thank you, Mr. Ngaitopi. Thank you, TCJ.
Thank you. On the question of whether in interpreting 3.1 we keep to the perimeters of the Competition Act is something that we may not be able to avoid. In a sense, the language in 3.1, I just found incidentally now, is replicated in Section 4 of the National Credit Act, for example. And therefore, the interpretation we come up with may live to follow us. And I'm not sure if different contexts would be a sufficient basis to distinguish that. So I just want your view on that. If we take a wide approach to effects, that it may well also cover unintended consequences. Traders in the Ukraine may agree to fix wheat prices in order to punish the Americans, but it may have an unintended effect on South Africans' ability to purchase wheat. And that would have been a pure relationship between, let's say, Ukraine and the US. But on the wider test, we would have jurisdiction, even if those chat rooms, discussions were totally silent on South Africa. So I just raised the unintended consequences of a wider effects test and the Section 3.1. I have one or two other questions, but I'd just like your response to that first.
Yes, well, on the National Credit Act problem, we would submit that we would accept that the interpretation we give should apply to the National Credit Act because they're basically sister statutes because they're both dealing with economic activity. So if it has effects, then it would be applicable. And then there's the other question, well, how do you interpret economic activity? You know, in other words, do you interpret economic activity to being any economic activity? Or do you interpret economic activity to include economic activity that's related to South Africa? So, for instance, if the example that you postulate, Justice, is there is price fixing, well, you know, the old cartel, OPEC, you know, so we are always affected by price fixing at OPEC, you know. But in a sense, that's not really sort of our economic activity. It's economic activity that's taking place outside. And so I think the constraint is economic activity itself, that it's economic activity that's obviously related to South Africa. It cannot be any economic activity anywhere in the world. And then the second question then is, does it have effects in South Africa? So you always have to draw the connection between those two. So I would say that our submission of an expanded approach to Section 3.1 will probably exclude that example, and it will be excluded by economic activity.
Okay, I understand your arguments, nevertheless, to move along the line that even if you have to fit into a narrower test of effects, that you fall within that. That's your fallback argument, correct?
Yes, if I fall under connecting factors, Justice Davis he asked the wrong question. The correct question is suit and conduct. On that question, you have to ask, what is the most appropriate and convenient place for the litigation to take place? And here you've got 4 unanswerable factors that show that South Africa was the right place, including the subject of the manipulation, which is the rand itself. So the long answer is yes.
Okay. In your argument, you take the view that if subject matter jurisdiction is established under 3.1, then you don't need to establish personal jurisdiction, correct?
Yes, but yes, only Justice Colopin with this qualification, 3.1 established territorial jurisdiction and subject matter jurisdiction. On territory, it's extraterritorial. On subject matter, it's economic activity.
Okay, even though it's extraterritorial, that doesn't necessarily answer the question of personal jurisdiction, not so?
No, it doesn't answer that, yes.
Sure. And my question to you is that if we are to develop the common law, if we're not with you on your primary argument,
yes,
then the whole doctrine of effectiveness has received considerable attention by our courts to the extent that its very rationale is questioned.
Yes.
And it's been regarded in some courts as being fictional.
Yes.
And even though I think in one of the CAG judgments, reference was made to it being rational and legitimate as a governmental objective. But when you look at some of the pronouncements, particularly in the case of Tsung, in FIFA and Sedebe, and in Thermo Radiant, the courts have really questioned the effectiveness of the doctrine for a number of reasons. The one, that there's no realistic relationship between the amount of attachment and the value of the claim.
Yes.
Secondly, it's determined at the commencement of the action.
Yes.
So if the value of that attachment diminishes to 0 during the course, so let's assume you attach shares, and during the course of the litigation, the shares plummet to 0.
Yes.
You can't really speak of effectiveness. And I found an interesting example of a horse being attached, and if the horse should die during the course of litigation, well, so much for effectiveness. So what's your take on, it almost seems that if you look at the CAG judgment, there's a kind of quid pro quo.
Yes.
Is we're giving up the whole idea, if we should relinquish the idea of attachment, not as a universal principle, but in these cases, then in return, we need something else, and we need these connecting factors. But if the very essence of an attachment may well not meet the test of rationality and legitimacy,
yes,
then should we still consider that as a matter of principle in how we develop the common law.
No, I submit, no, and there's another example, Justice Colapen, service. You know, a CEO of Nomura flies to the Johannesburg International, or Tambo, and then you find them there, you give them a summons. You know, that actually suffices. Then he flies back, but there's now jurisdiction. Which goes back to this thing that actually these are arbitrary categories. When you try to examine them closely, they are arbitrary categories. It's a fiction that we have in mind. It's a fiction about effectiveness, but it's not related to the actual forces of commerce. The other is we run the litigation now, and which is true, some of the foreign banks have closed shop in South Africa. We run the litigation now, they pack up and they go, and you can't actually determine the turnover at the time because there's nothing. And according to effectiveness, then jurisdiction is gone. So it's actually a fiction, which is why we say don't hold on to a fiction.
Notwithstanding that, what if someone would say to us that what you're embarking upon is something that is very foundational to our law, the whole question of jurisdiction, that has a long history but has its own consequences, and perhaps this is not something for the court to consider, but it may well be something that if ultimately it needs reform, it needs development, is best left to the participative and deliberative processes of the legislature.
Yes, only if, I mean, I think the courts are actually behind. The legislature has done the job, and that's really the problem. The legislature has told us that Section 3.1 applies to activity inside or having an effect, and that disjunctive was instructive. So I think it's not that the courts are ahead of the legislature, the courts are behind. They have not yet caught up with where the legislature is.
I'm not sure if I'd agree with that assessment, but those are the end of my questions. Thank you.
Well, you read another section from the Consumer Protection Act, you know, which is to the same effect. So again, you know, it's 2-0.
Thank you.
Mr. Toby, I have a few questions on preemption and then the Section 3.1 issue, but also on the SOC. So let me start by referring you to the record, the referral, volume 5, page 391. And this deals with preemption, which has already been covered, but I want to ask you this, just this one question on it. In paragraph 50 in the referral affidavit, Mr. Ngobesi says that the tribunal has jurisdiction over the foreign peregrini by virtue of the following connecting factors. So what you are doing here is you're laying a basis to overcome what has been laid before your door in respect of the foreign peregrini.
Yes.
Now, there is some of the respondents, or most of them who deal with this aspect, say that in doing this you have preempted any possible appeal. Just on that another aspect.
No, Justice Machid, you see, if you look in the following paragraph, we had to plead both of them, otherwise it was too risky. Because if you read the second one, then the next one, the next paragraph, 51, that's simply talking about economic activity having an effect in South Africa for the purposes of Section 3.1 of the Act. You see. So, and then 50 is about the connecting factors, so that we are able to argue both points. But we couldn't take one point and not the other. So there is no basis to say this is preemption.
You are saying you are covering all bases, but your argument is Section 3.1,
yes,
period.
Indeed.
And you covered the other base just in the event that the court is not with you.
Yes, because we knew the problem, because we had run the argument in 2020. It was not accepted. We ran it again in 2023. We are running it for the third time.
And the second one deals with Section 3.1. Now, I've marked them as your main written submissions, but they are not really, and I've contrasted them with your consolidated submissions, where you make general submissions and then you deal with the banks. Yes. So the shorter one I call the main submissions. And at page 35, paragraph 22, I mean, if you don't find it now, it's fine. I'm just going to read to you what you say here. You deal with Section 3.1, and then you say, the CAC's common law, is the point you made earlier, the CAC's common law approach offends the Section 3(1)'s purpose of the Competition Act. But then at the end you say, at the very least, Section 3(1) changed the common law by doing away with personal jurisdiction. What does that mean?
Well, it means that there is no need to inquire into personal jurisdiction in order to establish whether the tribunal has jurisdiction.
That's different to saying it changed the common law.
Yes.
Why I ask you this? Let me say why I ask you this. I mean, some of my colleagues have dealt with the implications of this expansive interpretation of Section 3(1). By saying expansive, I'm not saying that it's wrong. You may be right. But some of my colleagues have dealt with it, and this particular submission in these written submissions, some of the respondents say that by that you are conceding that the common law is there, but it's an exception to the common law. In other words, the common law has been changed by Section 3(1). So they then say there is this presumption that the legislature is presumed to have altered the common law as little as possible.
Yes, Justice Machida. I mean, insofar as the arguments of my learned friends, there's a lot of straw manning here in this, like lots of straw men. You know, you latch upon a word and you say, well, but the rest of the argument is so clear, because the rest of the argument in the heads. Section 3(1) is not constrained by the common law. The Competition Act introduced a statutory delict. That statutory delict has no foundation in the common law. And it also defined its ambit and territorial basis. So you can't strawman it by saying, look at this word. I mean, that's not a proper way of reasoning. If I'm wrong on that, I say I've got enough adequate connecting factors.
The referral affidavit on the SOC makes makes some general submissions or contentions, and then it deals with individual chat room activity, and then it deals with market conduct.
Yes.
Now there's an argument, I think it's by HSBC, that says when you make the argument generally, but also even specifically, in one instance, for example, there's allegations of collusive conduct, but then it is said to have led to a sharp appreciation of the rand in a certain instance, and they cite, I think, collusion in 270.9.1 of your affidavit. And on the other hand, it's alleged to have resulted in a decline in the USD ZAR exchange rate. So what they are saying, the collusion on your referral affidavit pulls in different directions. Is that? I try to understand that and see if that has merit.
Yes.
So what they're suggesting is that if there's collusion among these traders in the chat room, the net effect should be that the collusion should all pull in the same direction, not in different directions.
No, no, that's plainly wrong, because because it always depends on what you're trying to do, you know.
Whether you're pushing the buy or the sell.
Yes, exactly. And so it will always pull in opposite directions, depending on your profit motive at that point in time. So that's not a contradiction. It just shows in that instance this was the effect, in another instance this was the effect. Bearing in mind, Justice Majid, that what we have to establish if the trial runs, effects are only necessary for jurisdiction to get into the room. But for Section 4(1)B, we don't have to show effects. We simply have to show that there has been an agreement. Yes.
And I suppose that same answer applies to this argument that you can't apply this uniformly because there'll always be a buyer and a seller. I suppose the same answer goes there.
Yes. And the key part that they all overlook, you know, they sort of create this confusion. You know, when you create complexity, you create confusion. They create this layer of complexity about the relationships between these banks. What is unmistakable is that these are traders in forex markets. They are competitors. Their customers are confidential information. The agreements they have with their customers are confidential. This affidavit lays it bare that they removed that confidentiality.
Then this penultimate question on the SOC from my side is this. There's also an argument that we're not dealing here with shares traded on a single platform like the JSE or the DAX or in Frankfurt or wherever. We're dealing here with a currency that is traded on multiple platforms. So they say that your allegations are simplistic by equating it to a single platform, whereas here there are multiple platforms, and therefore you can't look at it sort of uniformly. There's no single exchange rate, they say.
Well, it's unclear what that actually means for the purposes of establishing, because an SOC on conduct is simply whether there is an agreement or coordination. So that's the first answer.
Do I understand that? Do I understand that answer to mean that that may have some bearing at the trial, but not at this point?
Yes, it may have a bearing on the trial, and it may be a defense. I'm not sure what kind of a defense it will be. You know, there are new defenses now. The competition lawyers have not stopped creativity. They have something called characterization, which no doubt they're going to say characterize this conduct. You know, but they have their defenses. This is not the stage.
Last question on the SOC and overall is this. Your case is that, let's just leave market conduct aside because that's a completely different ballgame. But when you deal with activities in the chat room, you say that you don't have to be actively participating in the chat room. You can just be passive.
Yes.
Because being there, you acquire knowledge.
Yes.
But you also say that you don't even have to be in the chat room to be implicated as long as you're aware of what's going on. Or am I putting that broadly or badly or both?
No, we do say, because insofar as there are two banks where we have no evidence, and one must remember where we are.
Those are the two local banks, Nedbank and RMB.
Nedbank and FirstRand.
And FirstRand.
RMB, yes. That have no participants in the chat room. But one must remember where we are in the trial. We don't know if they have no participants in the chat rooms. We pleaded what we knew at the time, which is patterns. So we would say, yes, if your trading pattern fits the fact pattern of the participants in the chat rooms, you are in the SOC.
Just to draw it through to its logical conclusion, you say in the case of Nedbank and RMB, even though they didn't have participants in the chat room, either active or passive, the fact that their trading pattern conforms to what was discussed there implicates them sufficiently on the allegations at exception stage.
Precisely. And there are two further factors that my learned friend mentioned. The one is the currency, which is it's the common product. The other is common players, the overlap between international and local. The same banks that are in that chat room, these are the banks that they are discussing with. Well, these are the banks that they are coordinating with.
I may or may not have a question for Ms. Zikalala on the initiation and PICFITS. Because there's a different interpretation of PICFITS from the respondents. But I will leave it for now and see if some of my colleagues want to ask you questions while you're on your feet so as not to inconvenience you. As I say, I may or may not have.
Yes. Thank you, Justice Machid.
Thank you. Good afternoon, Mr. Mkaitobi. I want to revert to the conduct attribution debate that you had with my sister Tron, but and as well as the last point touched on by my brother Majid, with regard to Nedbank. You, in argument, you said that the CAC did not mention Nedbank at all.
Yes, yes.
And that it did not mention Nedbank in its judgment too. But it seems to me that it did, although not under a separate heading. If you have regard to paragraphs 163 and 164, where it deals with the position of Standard Bank,
So, Justice Musi, you are at which page?
The paragraph 163 and 164 of the
289.
CAC judgment, let me give you the judgment, 289.
Yes, I've got that.
So it seems to me that the issue was dealt with, but not under the heading of Nedbank.
Where are they mentioned in 162, you say?
163 and 664.
163.
Yeah.
No, but that's the conduct of Standard Bank that is being analyzed.
No, but then the CAC says the following about Nedbank. It says Nedbank had no trader who was employed by it or who represented it. That's the one point. And then secondly, the CAC said, well, the allegation was that EPSA and Standard Bank withheld quotes in order to enable Nedbank to fix the exchange rate. And it said, well, the relevant date here was the 1st of January 2008, which is a public holiday in South Africa. And the fact that they did not participate is not necessarily a withholding for nefarious reasons. It's just that it was a public holiday.
Yes, well, I mean, that's also another speculative. But let me answer the main issue, which is the mentioning of Nedbank. The conduct in issue is the conduct of Standard Bank. What they're saying is that how could Standard Bank collude with an unnamed trader? That is what is being said. Our objection is a substantive objection. What do you make of all of the market data we've given you? You can't just ignore it.
But we can't also ignore the fact that the CAC did mention Nedbank's involvement.
Yes, but it was talking about attributing the conduct to Standard Bank. So you remember that what they said in paragraph 85 is that in order to find that you are in the SOC, we need to find a trader. Yes, so Standard Bank cannot collude with a non-trader, according to them. That's the way that they've reasoned it. So they say we can't find a trader that side. And then they say that the issue around the 1st of January, I mean, that's just a speculative issue. But they never say to the Commission, these are the allegations you've made against Nedbank. They don't meet the requirements for the following reasons. Which is why Nedbank does not even feature in the judgment as a heading. Each and every other bank features. They come to them later when they say you can't join them. I understand that. But on the SOC debate, Nedbank doesn't feature. I'm not saying they're not mentioned in the judgment, but they are simply not analyzed.
Thank you.
And by the way, I'm not sure, Justice Musi, if you were here in Vodacom, don't know what you would have said about this judgment.
Mr. Ngubengatobi, in regard to whether it is open to you in this court to re-argue your initial interpretation of Section 3.1, and particularly to argue that it dispenses with the requirement for personal jurisdiction. I understand your argument to be it is self-sufficient in itself for all jurisdictional purposes, and any effect in South Africa confers subjects affirmed to personal and subject matter jurisdiction.
Yes.
The banks that take the point against you on that either put it on the basis of preemption because you didn't seek leave to appeal and instead sought to comply with it in your superseding referral in June 2020, and you responded that you covered several bases there, not just one base, or raised judicata. Now, it seems to me preemption would be relevant if you were before us seeking leave to appeal against the first appeal court judgment, because then they would be saying, well, you've preempted your right to pursue that appeal. But am I right that you do not seek leave to appeal the first appeal court judgment?
No, I don't. I need to qualify what I've said, because, you know, when we were in the, anything you say that's vaguely wrong is seized upon by 5 people. I need to qualify this. We do say you must correct it. in the sense that you need to articulate the correct statement of the law.
But we have no application before us seeking leave to appeal against it.
No, you don't. I don't want leave on it. I've not applied for leave on it. But if it's an incorrect statement of the law, it's open for you to correct it.
So in this court, your entitlement to re-argue the Section 3 point depends solely upon whether you can do so in the face of the first appeal court judgment, or does that judgment render that point res judicata?
But it can't render it.
Now, I just want to understand that if it's not a preemption point, because you're not seeking to appeal against the first appeal court judgment, it could then, if it still is an obstacle to you, it would be a res judicata point.
Yes, that's correct.
Now, is it correct that the first appeal court judgment considered, you said somewhere in your argument that the appeal court shut you down when you wanted to argue Section 3. I assume that was in the second appeal court.
It was in this, no, you know, Justice Rogers, suppose you can watch this on television, it's all there. He refused to entertain the argument. We raised it.
Yes, was that in the second?
In the second hearing.
Yes, no. And he might have done so on the footing that it was decided in the first hearing, but I'm more interested then, it was argued in the first appeal court hearing.
Yes.
And
no, I don't think he said that it was already decided. What he did say is that it is about subject matter, Section 3.1.
So the first appeal court judgment considered your argument that Section 3 dispensed with personal and subject matter jurisdiction. It rejected it and adopted the adequate connecting factors test.
Yes, that's correct.
And part of its order was that you were required, as against the pure Peregrini, to plead adequate connecting factors to establish personal jurisdiction.
That's correct.
Now, do you say you're simply not bound by that?
No, I say you are not bound by it.
No, but before we can get to whether we are bound by it, we need to know whether you are bound by it, because if you are bound by it, we can't allow you to argue it afresh. We might say that we don't need to decide the point. It might arise in some other case. That's the effect of res judicata. If a point was argued and decided, and it set, as it were, the framework for how the case was to go forward, and everybody dealt with it on that footing thereafter, we can't, a person can't relitigate a matter just because the first decision was wrong. If they are bound by it, they are bound by it, and a court before whom that question comes between the same parties for a second time says, I don't care whether the point is right or wrong, it is binding between these parties. So that's the question. Does the first appeal court judgment have the quality of rendering that issue res judicata, and if not, why not?
Well, firstly, Justice Rogers, we do not accept that it made the point about jurisdiction res judicata.
And why not?
We've never considered that. Well, firstly, we say this was in the middle of litigation, and it was basically to give the Commission guidelines on how to reformulate its pleading. That's number two.
Yes, but there'd be little point in guidelines if the Commission could say afterwards, well, thank you very much, but we're not going to bother with those guidelines. We are going to carry on arguing what we argued before. A central argument, you even lost this point before the tribunal the first time round. They would have gone further than the appeal court. You argued the point in the appeal court in the first time, and they said, going forward, this is how they decided as a matter of law that Section 3 did not dispense with the requirements for personal jurisdiction, but they accepted a development of the law, at least in regard to competition matters, that adequate connecting factors would need to be pleaded, and they ordered you to plead that if you wish to carry on against the pure Peregrini.
Yes.
Now, I battle to understand a position where in proceedings that were intended to resolve what had been an unsatisfactory case put up by the Commission prior to that, that wouldn't then be binding. You could have appealed that and said, the Competition Appeal Court is requiring us to prove personal jurisdiction in circumstances where we don't need to establish it. That was a wrong finding in law. That could have been appealed there and then.
Justice Rogers, I suppose it depends on this central point, and this was the third point I was about to raise. It depends on whether or not this court accepts that, because this is a jurisdictional issue, it's whether there's power or there's no power, and that depends on the interpretation of the statute.
So there's power on whose part?
On the tribunal's part.
Yes.
And that's a legal question that you must answer. Was that decision correct or not? But insofar as we, as the Commission, are concerned, we complied with the order because we pleaded the connecting factors that we were alleging. And then we made an alternative effects-based plea.
Then if I can move off that to a question of our jurisdiction rather than the tribunal's jurisdiction.
Yes.
I can frame my question with reference to Ms. Hobden's submissions, but I suspect you may feel you can answer it because I could ask the same questions in regard to the pleading of adequate connecting factors. During the course of both your submissions and her submissions, there were statements to the effect that the Competition Appeal Court misunderstood allegations in the referral affidavit, disregarded other allegations, and then particularly in Ms. Hobden's submissions, there was a summary of what the facts alleged were against particular banks, and could they reasonably support a particular inference, namely participation in the SOC. Now, taking a question like, do the facts alleged in the referral affidavit support as a reasonable possibility an inference of participation in the SOC? On that issue alone, isolating that, assuming the appeal court assessed the facts wrong and thought that those facts would not justify reasonably that inference, whereas you say it should have found that they could, is that an error of law? And if it is an error of law, is it one of general public importance?
Yes, we would submit. I'm now going to answer it on that basis because I want to say something else about what the actual findings were on which banks were excluded and for what reasons. But we would submit that if they made legal errors on attribution, so take one error, because the only instance that is mentioned is one and not multiple. Therefore, you cannot be attributed as a participant to the SOC. Now, that's an error of law.
Well, is it an error of law, or is it the court saying, we do not consider that one pleaded instance is sufficient to draw the inference? Doesn't necessarily mean that in every case, one instance won't be enough. But in this case, having looked at the fact that there's say, a conspiracy that is alleged to have gone on from 2007 until at least 2013, with several hundreds of specified instances of chat rooms, but a particular bank, say, is only involved in one. Could a court asking itself, would this reasonably justify an inference that this bank participated in the SOC as a whole and was aware of or could have been aware of all the participants in it? Surely the court can take into account, it may do so wrongly, it may be a factual error, but to attach significance, for example, to the fact that a particular bank is mentioned only once. And then, just to add to that, there was an argument, I think it was Ms. Hobden's argument, but you've emphasized this point as well, but you must also take into account that there's economic evidence. But all of that is factual. And if I can foreshadow, because I don't want to put you right onto the spot now, although obviously I will invite you to give your answer, what would assist me, and it would assist me in regard to the adequacy or the appeal court's alleged wrong findings of the inadequacy of the pleading on two matters which are related, the adequate connecting factors, assuming that is the correct test, and knowledge of and participation in the SOC. What I would find useful is a list of the errors of law that were made, and And I think to identify them as errors of law, they ought to be capable of being formulated without reference to the facts of this case. In other words, the law is this, but the appeal court said that the law was that. And I think at some stage, subject to the direction of the Deputy Chief Justice, I would find it useful if those errors of law were clearly identified because, and I don't criticize you or Ms. Hobden for this, but in the course of submitting the justification for your case in respect of each bank, there was seemed to me quite a lot of mixture between alleged factual errors and things that might or might not be errors of law. And perhaps once that list is compiled, you could let your colleagues for the respondents have it and at some stage hand it up to us, and whether it gets elaborated upon at a later stage in reply or if we have time. That is what I'm looking for. But to go back to our instance, say, of the bank, do you say that we can go somewhere to the appeal court's second judgment and find a statement that is wrong in law?
Yes, that is the only argument we've been raising, is that these findings about non-attribution are actually errors of law. We've never said these are errors of fact. We've said they are errors of law. So I was going to go back to Barmley, Mary Lynch, and Barnum. Now,
Sorry,
why were they?
To which bank?
First, 20th, and 21st.
The Bank of America
Yes.
respondents, yes.
All right, so the first issue is, why was Cook excluded? Okay? He was excluded because there was no evidence that he conspired with the South African bank. So you see the legal basis is that in order to be in, you must have conspired with the South African bank.
You mean have had direct dealings with the South African bank?
That's an error of law. Which
now one could formulate that to say, in order for a foreign bank to be party, or any bank perhaps, to be party to an SOC, they must have dealt. Do you raise that in the context of personal jurisdiction?
No, that's what I'm saying, that in the judgment, this is under that section dealing with Barmley, Mary Lynch, and Barner.
Yes.
And there's no separation between SOC and jurisdiction.
Because one of the prime, perhaps the main connecting factor in the conception, at least of the appeal court, was the fact that the Pure Peregrini were involved in an SOC that also involved South African banks. But you say it went further, it said they must have actually dealt with those South African banks. Yeah. So there you could formulate the error of law. In order for a Pure Peregrinus to be party to an SOC, it must have dealt directly.
Yes.
Yeah. So that would be an example of how, and identifying which paragraph of the appeal court judgment contains the error.
Yes, no, I accept that, Justice Rogers. I have no problem with it. I'm simply pointing out that when you say that our submission was a mix of fact and law, that's actually not accurate. We've actually identified errors of law, such as the one I'm identifying. But I'm happy to redo the exercise exactly as you're requesting.
Yes, and as I say, framing the question of law without reference to the facts of this case probably assist in not mixing it up with factual assessments.
Yes, indeed.
Then, can I just check some? In the second appeal court hearing, was the question argued that the court could not permissibly take account of facts raised in dismissal applications by the respondents?
Yes, that was taken.
Yes, so it is a matter of surprise. Am I right that it's not addressed in the appeal court's judgment?
No, it's not. And interestingly, it is addressed in the tribunal's ruling.
Yes.
Yes.
Will you say the tribunal did the right thing? It took a permissible course in treating them as condoning the irregularity and treating them as pure exceptions?
Yes, it treated them as pure exceptions, yes.
Also, on the question of what might not have been properly canvassed in the second appeal court judgment, the position of Nedbank, assuming for the moment, just leaving aside what my colleague raised about certain paragraphs in the appeal court judgment, on the assumption that the appeal court judgment contains no reasoning in relation to Nedbank, one knows from its other reasoning it would have said, well, we can't join them because they came afterwards. They are part of the late parties.
Yeah, no, we consider that they found that.
Yeah,
That's true.
That might be a basis, but if we are with you that respondents could have been joined after the June 2020, then what do we do with Nedbank? Do we have to then undertake our own analysis of the adequacy of the case against it because we have no reasoning to deal with?
Yes, because it's just one. I mean, it's unlike, I suppose if it was, 80% of this thing was this bad, then I would say maybe then you shouldn't. But if it's one bank, then I would ask that you should conduct your own analysis.
And I suppose we have, yes, I'd have to go back to the second tribunal decision to see to what extent they dealt with it. But if we're with you on joinder, we can't duck dealing with it.
Yes, you must still decide whether we've correctly attributed the SOC to it. That there's no problem of jurisdiction because it's an incolor.
But just to clarify, you said you were attempting in your address, and Ms. Hopton perhaps was attempting to do the same, always to circle back to errors of law. Do I understand that you will accept that criticisms that rest on contention such as the appeal court misunderstood our referral affidavit or ignored certain parts of it, errors of that kind alone would not engage our jurisdiction?
I think that's ordinarily the case unless they illustrate a lack of knowledge or awareness of the facts, which is the test you've now formulated in Vodacom.
Yes, at the moment we don't seem to have that case before us, but...
well, the problem is this, if you say that the referral says X, but it actually says Y, that's evidence of lack of awareness of the contents of the referral, and that's a legal question.
Just wanted to check.
So just to make sure that, again, no one says, you included things that are factual and you were prohibited from doing so. We will include those things where there is a distortion of the referral because they indicate a lack of awareness of what is contained in the referral.
In the context of saying that an allegation of representation is sufficient for authority, at least at the exception phase, even though the bank in question may not have...
Sorry, Justice, I didn't hear
that the question, that an allegation that a particular party was represented by a trader is sufficient for authority, even if that firm didn't employ the person. You referred to an SCA case, and this is just a, if you don't, do you have it close? I didn't catch the reference, and I don't think it's in your submissions.
I would need to ask.
It's the Northview Shopping Centre case.
Ms. Drake.
Northview
Justice Madrid was in the SCA at the time.
Well, apparently some of my colleagues will be able to give it to me if you don't quickly find it.
Yes. I'm sorry, I can't find it now.
10 case, Northview Shopping Centre, I think, Mr.
It has been found. It's Northview Shopping Centre versus Revelers Properties, Johannesburg, CC and another. It's reported in 2010, volume 3, SA 630. I think we referred to paragraph 28. I see Justice Mlambo was in that case.
Yes. Thank you. Those are my questions.
Thank you, Justice. We will try to do this exercise, hopefully by first thing tomorrow morning. Well, I know it will be done by my juniors. Hopefully they'll get it done in the morning.
Mr. Ngugaitobi?
DCJ, I'm in your hands.
No, I'm still here.
Yeah, sorry, Justice Mato.
If you are able to successfully persuade us that the second CAC judgment misconstrued the section, the impugned section, section 3.1, by introducing a different test, like the qualified test, which is borrowed from the US and the American and the UK, that would, in your view, constitute an error of law?
Yes.
that would ground this court jurisdiction?
Yes, we submit that. That is correct, Justice Matopo. I don't want to now vicariously respond to Justice Rogers because he says, well, what about res judicata? But I would say that if I can convince you that the judgment is wrong, you must overturn it.
Insofar as the approach by the CAC on the exception, does the fact that it applied a different standard by reading in evidentiary requirement, does that also invoke the jurisdiction of this court? As you would recall, it alluded to plausible evidence. Would that on its own, assuming that would have been, or that was, the only issue that we had to determine, would that ground our jurisdiction?
If it overlooked evidence.
Yes, the misapplication of the standard
Yes.
by the CAC on its approach to rules relating to exceptions.
No, probably no. I mean, we would have to show, if we are complaining only about the facts, we would have to show that if we say in paragraph 20 that Cook was employed by Bamley, I'm just making a rough example. In your judgment, you say, you allege that Cook was employed by Nomura. Then it's an egregious mistake, which shows a lack of awareness of the pleading, which we say is an error of law, because we are entitled to have a dispute adjudicated properly. But if we say, well, you've said that one of the factors I take into account is the frequency of participation. I think 1 as opposed to 30 is insufficient. Yes, then I accept that that might fall under S versus Busak.
Well, as you and I probably understand the rules relating to exceptions, we borrowed same from the High Court rules and as in the Competition Act. Does the rule in the High Court deals with plausible evidence? And was the CAC correct in its finding that the tribunal had, or the commission had to lead plausible evidence?
No, it was wrong because throughout it's actually talking about evidence. It's not talking about facta probanda, the pleading itself, which is what is required right now. And one of the problems, this is what I suppose Justice Rogers was coming to around the correct standard. One of the problems with this case is that we raise a pleading. Inside of the banks answering the facts, they bring their own application with new facts that have nothing to do with what is pleaded. Then the tribunal says, look, this is intolerable. We're going to treat this as an exception. In an exception, no new facts. And this is not a case about evidence. It's everyone accepting that if what is contained in the commission's referral is proved at trial, does it disclose an action or not? Now, if you misunderstand that question, that's an error of law, which you would be entitled to intervene.
Would that not fall within the sui generis approach of the Competition Appeal Court? That you could, in the course of adjudicating such disputes, look at the additional evidence or the new evidence? Would that not fall within their remit?
No, they wouldn't have the power to do that. It's the tribunal that would have the power to decide whether additional evidence is required or not. What it decided in this case, it decided that all of these applications to dismiss will be treated as exceptions, which meant that no extraneous evidence. And one of the problems with the judgment is that it actually doesn't engage that reasoning of the tribunal, whereas it was one of the points we raised, which we still take even now.
Can I just share with you my difficulty?
Of course.
As I was preparing.
I hope I can help.
Yeah, as I was preparing for this case, and it's more or less the same concern that my brother Rogers J has dealt with. My point of departure was to look at the CAC order and also look at the first CAC and the second CAC order And then I had to ask myself, absent any appeal, are you precluded from raising the issue? And I looked further and said, there was that order, and which required you to do certain things. And you did those certain things, you reconfigured your papers. Is it permissible, or it's permissible for a party to argue that having done that, you cannot raise it at any other forum? This is the debate that you had with my brother Rogers, but albeit I'm putting it differently.
Yes, no, I accept that. I mean, if we had not complied, and we know the standard of compliance, you look at the object of the order to see, did you fulfill that object? If we had just decided we're going to do whatever we want, we don't care, then I understand there is a problem, because the commission is an organ of state. But in this case, this is a legal debate. We did two things. We said jurisdiction exists because of Section 3.1. Jurisdiction also exists because of adequate connecting factors.
Are you saying it cuts across all the other findings that were made by the CAC 1 and CAC 2?
Yes.
So if both courts, for lack of better word, fudged it or botched it, you are still entitled, as a matter of law,
Yes.
to raise it before us?
Yes, precisely. That's probably the best articulation of what I've been trying to say, that as a matter of law, I'm entitled to ask the Constitutional Court to correct a legal mistake that has been committed by the Competition Appeal Court. The fact that it's committed twice doesn't make it right.
Okay.
I have questions for Ms. Sikalala, please.
Well, I suppose if there are further questions for me, then the DCJ will invite me.
Just to carry on with this jurisdiction debate you had with Justice Rogers and Justice Matopo, I note that in CAC 2, the court still expressed a view regarding personal jurisdiction and subject matter jurisdiction. And I want to link that to the question that Justice Matopo asked you, because it seems to me that in CAC 2, rather than speak more about personal jurisdiction, the court went further. And with that in mind, is it your submission that you are perfectly entitled to raise the Section 3.1 argument with that landscape that we have?
Yes, Deputy Chief Justice, I'm submitting that if you look at what they did, they introduced a new requirement which has no basis even in the 2020 order. The requirement that there must be an actual relationship between a foreign bank and a local bank.
Yes.
That is not even a basis in the old order. The old order appeared to us to be a modest finding based on strong connecting factors between the suit and the conduct. Now, then they say, oh, no, that's not enough. We are going beyond what we said is the development of the common law to actually require a South African bank and a South African trader in each instance.
Yes.
Now, I'm entitled to say the second judgment is wrong because it does not apply Section 3.1, and because it's a pure question of law about Section 3.1, what does it mean? You are entitled to intervene and to correct it. And it doesn't matter that they have previously got it wrong. They got it wrong twice, but I'm asking the court to correct it.
Thank you.
I suppose I could call Ms. Sigalala then. Yes.
For a supper.
Thank you, Deputy Chief Justice.
Ms. Sikalala, I want us to look at the purpose of Rule 15.2 of the Tribunal Rules and the similarity that it has with Rule 18.4 of the Uniform Rules of Court. And would you agree that the primary purpose of these rules is to prescribe that parties must be clear in their pleadings so that the other side can respond appropriately?
Justice Turan, I have Rule 15.2 before me, but I don't have 18.4, but I would agree with that, yes.
Yes.
Rule 15.2, though, requires that the Commission plead a concise statement on the grounds of the complaint, the material points or material facts or the points of law relevant to the complaint relied on by the Commission in the complaint.
So you would agree that the primary purpose is to prescribe that parties must be clear in their pleadings so that the other side can respond appropriately?
Yes, Justice Turan, I would agree with that.
And would you agree that the purpose of the CAC 1 order was to allow the Commission to supplement and amend its pleadings to make out a cause of action for a single overarching conspiracy?
Yes, that was one of the purposes of the CAC 1 order, and it was also to streamline the referral affidavit. They were to make it one affidavit and to just enable both the Commission and the parties to understand the case that was brought against them.
Now, I'm struggling to understand how Pickford assists the submission that you made that Rule 45 of the tribunal rules permits joinder or substitution of parties. On my reading of Pickford's, it speaks to the competence of adding respondents who ought to have been added but were not cited at the initiation of the complaint. How can Pickford's be authority to allow for carte blanche joinder of respondents?
Yes, so Justice Turan, Pickford speaks to Section 49B as to whether the jurisdictional requirement for having initiated a complaint as against conduct has taken place. Pickford answers that the jurisdictional requirement is met once you have initiated against the conduct and not necessarily the explicit parties in that. Once that jurisdictional requirement has been met, then the tribunal has the ability to be able to exercise its powers. So yes, in relation to Pickford's, that was in that didn't, so let me answer this specifically. Pickford's, our interpretation of Pickford's is taken to the logical conclusion thereof. Once it was decided in Pickford's that once you initiate against the conduct and the consequences of initiation run as against that party, even when they're not explicitly named, then that jurisdictional requirement has been met, and then the tribunal then has the power to be able to exercise its powers in terms of the act.
But it also brings me back to my initial question, in that the purpose of the CAC 1 order was to allow the Commission to supplement its papers to make out a cause of action for a single overarching conspiracy. And how does that give the Commission then carte blanche to join the respondents that it wants to join?
Justice Turan, so I'm understanding your question relating specifically to the issue of joinder and not in relation to the issue of initiation.
It's linked to the applicant's reliance on Pickford's.
Yes, Justice Turan. I have already, in my initial address, outlined the fact that the CAC order, the 2020 order, asked the Commission to streamline its affidavits, asked the Commission to plead, but the power to join parties, the power to determine matters of procedure, doesn't stem from the CAC order. They stem from the Act, because the Act empowers the tribunal to be able to determine its own matters of procedure in order to be able to run its processes. So, yes, the Commission was required to streamline its affidavit and was required to plead that. But in the absence of the CAC having said, you're also precluded from exercising your powers in terms of the Act, the tribunal was entitled to be able to exercise the very powers that's been given to it, not by the CAC order, but by the Act.
And that includes the power to supplement and amend its pleadings.
The Commission was asked to file a new referral affidavit in paragraph 3.3.1. It filed a new referral affidavit, and in that it cited those parties, but that was the requirement of the order, to file a new referral affidavit. The Commission didn't supplement its pleadings. It filed a new referral affidavit in which it cited additional respondents, but it was not precluded by the 2020 CAC order in order to be able to do so.
So, in filing the new referral affidavit, was the Commission acting in terms of the CAC 1 order?
Yes, it was acting in terms of paragraph 3.3.1 of the CAC CAC order, which directed that it must file a new referral affidavit.
Now, my difficulty is that order cannot be used to allow the Commission to carte blanche join parties that it wishes to join. That's what I'm struggling to understand.
Justice Saran, our submissions are that when you read that order, there's nowhere in that order where it excludes or it precludes the Commission from being able to join parties. The use of the term named respondent was merely to correct the earlier order of the tribunal. It was not, and there's no reasoning in the judgment itself or in the order that suggests that the Commission was excluded or precluded from joining further respondents, and that the tribunal's powers to consider that application had now been restrained when you read that order. It just simply doesn't read that way.
So because the order doesn't restrict that, then the Commission is saying it has the power to join new respondents then?
Justice Turan, the Commission may bring that application to join new respondents, but the tribunal, as well as a statutory body, has to then consider that application, consider whether it is appropriate, consider whether it is convenient, consider whether it is fair to the parties to join them at that point. That doesn't preclude that. There's no prejudice that arises simply from bringing the application to join. The tribunal must still exercise its statutory powers to consider that application, consider whether it's convenient, consider whether it's appropriate, and to consider whether it gives effect to the tribunal's powers, obligations to run its proceedings with expedition and with informality as required by Section 55(2) of the Act.
Yes, thank you, Ms. Kalala.
I'd like to, as I say, I may or may not have had a question. It now turns out that I do have a question. And it concerns Pickford's as well. It's a related, but for me, more fundamental difficulty.
Yes.
You rely on Pickford's, specifically paragraph 21, as regards initiation.
Apologies, Justice Majid, I didn't hear you.
This deals with initiation.
Yes.
You submitted that Pickford's paragraph 21 permits you to initiate, to add parties at this point, because Pickford says you can do so after the referral. Let's look at Pickford's. In paragraph 5, the court says there was a 2010 initiation. That's the first initiation.
Yes.
Paragraph 6, the court says there's a second initiation, 2011. In 2015, there's a referral. Now let's look at paragraph 21. And just to interrupt myself, we know that Pickford's was added in the second initiation. Now, paragraph 21 says the initiation must be against an alleged prohibited practice. And it then says that parties could be joined and the initiation was in the first initiation for purposes of prescription, the trigger event. But we're not dealing with an initiation of a complaint here. We're dealing with a referral.
Yes,
Common cause, you added Nedbank and others after the referral.
correct.
And we know that in a competition law case, there's an initiation, there's an investigation, and then there's a referral.
Yes,
3 steps.
yes.
We're now at the 3rd step. So after the 3rd step, you join these, or you initiate, because that's what you do. You're not simply joining. You're initiating a complaint against these other respondents after the 3rd step. That's not what happened in Pickford's. Pickford's is authority for the proposition that an initiation is not against particular firm or firms, but against a prohibited practice. But here we've had an initiation, we've had a full investigation, then there's a referral, and then you add parties. So how does Pickford's apply in these circumstances?
Thank you, Justice Majid. So, Justice Majid, just to start at the beginning, Pickford's, as you've already articulated, is authority for the proposition that you initiate against conduct and not a particular firm. Our submission is that we have initiated against the conduct, and we did so on 1 April 2015. And once you have done so, you have initiated against all parties in that conduct, irrespective of whether they are named or not named. And this is important because initiation as a step has already been recognized by this court and in Yara that it is an informal process. It is against the conduct and it is an informal process.
Just interrupt you there, please. I don't want us to talk past each other. Do you accept, as a matter of principle, that Pickford's is no authority for the proposition that you can add parties after referral, as opposed to what Pickford's dealt with, initiation? For me, it's an important distinction, and I think we need to understand that that is the question that I'd like to be answered, please.
Justice Majid, we accept that Pickford's was not dealing with the referral stage of proceedings. It was dealing with the prior state before referral. So, but however, our submission is that once you have initiated against the conduct, the jurisdictional requirement to initiate in section 49B1 has been met. And then at that point, you can then speak to the issue of joinder. Those two things shouldn't be run as if they should run into one another. We have met the jurisdictional requirement to initiate against the conduct. That has been sufficient to meet the requirement of a referral. Now the issue in relation to those parties that are joined is one of joinder, not one of initiation, because we have already initiated against the conduct, and the parties don't argue that they are being added to conduct that is different to that to which we initiated.
Accept, or do you not, that initiation first and second investigation are jurisdictional requirements for a referral?
Yes, Justice Majid, that is the authority, the precedent that has been established, yes.
Now, just to put it bluntly, and not to beat around the bush, have you not added parties against whom there's been no A, initiation, and B, investigation? Because you've added them after referral.
Justice Majid, we initiated against the conduct, and initiation, because initiation is against the conduct, those parties that were added validly in relation to conduct against which we have initiated. The investigation is in relation to to determining that the prohibited practice is established. We conducted an investigation and also met that jurisdictional requirement. The issue of initiation has been met by the fact that we have initiated against the conduct and a valid investigation was taken and the matter is now at referral. What is at issue is one of joinder, but the tribunal's jurisdiction has been engaged.
Do you accept that that proposition you just made, that submission, is not supported by Pickford?
Justice Majid, we submit that, yes, the submission takes Pickford's to its logical conclusion, but factually, Pickford was dealing with it at a different point in time. Pickford was not dealing with it at referral stage. That I accept.
You see, in this court, because it's an apex court, we try as far as possible to practice judicial economy. So we only decide the case that's before us. And Pickford's dealt with this question. Can you, after you have initiated, and this in the context of when does prescription start running, because this was a Section 67(1) inquiry. So what's the trigger event? Is it the 2010 initiation or is it the 2011 initiation? It went no further than that. Referral was not on the radar at all. So I understand your submission, but I have difficulty in drawing it, as you say, to its logical conclusion. That is to attribute, since we're speaking of attribution here, that's to attribute to that ratio decidendi in Pickford's what it cannot possibly say. I mean, the judgment only says, for purposes of prescription, the initiation was 2010. That's when the trigger event, that's when the clock started running, started ticking. But we didn't draw, you can't draw it as far as referral exactly because, as I say to you, your jurisdictional requirements, the prerequisites in law for a referral are initiation and then investigation with extensive powers by the investigators. What do you say about that?
Yes, Justice Majid. I would say that the significance of the finding in Pickford's that the Section 67 time bar begins to run even before the party is explicitly named in the initiation statement is significant, because it means that a party, the two purposes for initiation, which is to begin the processes of the Act and to trigger the Section 67 time bar, have been triggered. And we would say then, the logical consequence of that is that a party has been validly initiated at that 2010 initiation, the first one, even though it is an initiation against the conduct and it has not been explicitly named. The issue becomes not one of initiation. The issue becomes one of joinder. It may very well be that then the tribunal may have to exercise different powers or so on in considering whether to join that party. But it can't be to say that the requirement of Section 49B1 to initiate against the conduct has not been met.
Now, I hope I don't sound facetious when I say this, but where would you draw the line? I mean, let's say we get to a point where this trial starts running eventually against the banks that remain, all of them, as the case may be. At what point do you draw the line to say you can still add parties? Like a few months into the hearing, some more names come up, add them. You've never initiated, but you know, you say you can add after referral. Come to the end of the hearing, it's time for judgment, court reserves judgment for a month or two. Can you still add them? Where do you draw the line? Where does all of this end?
Yes. Thank you, Justice Majid. Justice Majid, I know I keep repeating the statement, but in the first instance, we have initiated as against the conduct.
Argument, yes. Don't repeat it, please. I hear what you're saying, and don't get me wrong. I'm going to consider it, although it may not look like it. I'm going to consider it. But I want to know, there There must be a point in litigation where you say, and particularly in competition law litigation, where you say, you got to draw a line to say you can't keep on adding parties. Where is that line?
Justice Majid, when it causes prejudice, and that is classically a issue that one has to consider in a joinder application, whether it's convenient, whether it's prejudicial to be able to join a party. But it doesn't mean that the jurisdictional requirements of the Act were not met. It simply exercises the joinder requirements, the requirement particularly in the Act to act fairly to the parties. But that is essentially the line.
Thank you, Ms. Sigalala. I think you've answered the questions. Thank you.
Thank you very much. I think that's it in terms of questions. I know we had said we want to adjourn at 3:30, but
Justice DCJ, can I just get 1 second? I haven't considered the authority, but my team insists that I should give it to the court on the point of this court overturning a judgment that's not directly on appeal. Apparently, I think it's Justice Teron who did it recently. Where is it now? Sorry, Mutsila. Yes. Well, so she remembers it. Mutsila versus Municipal Gratuity Fund and others. 2025 ZACC 17, 8 August 2025. They say that that's the case in point. Thank you, TCJ.
thank you very much. I want to invite Advocate Falam to have his uninterrupted 30 minutes. We do adjourn at 4 normally, but we had intended to adjourn at 3:30, but we are here when we're all fresh and vibrant. So
Yes.
please go ahead, Mr. Falam.
Yes, the
Thank you very
3:30,
much.
the fresh session.
You represent the first, the 20th, and the 21st respondents, isn't it?
Indeed. And Deputy Chief Justice, Justices, I'm speaking first because for reasons not quite clear to me, Bamley was cited as the first respondent and no one else has volunteered to open the batting. So I've got 30 minutes to deal with some general issues and then some BOA specific issues. Now, the first issue to be addressed concerns the question of what the Commission could legitimately seek to raise in its application for leave to appeal against the second CAC judgment of January 2024, CAC 2, and any appeal arising therefrom. Now, the Commission contends that an appeal from CAC 2 could legitimately include a consideration of the Tribunal's jurisdiction in respect of extraterritorial conduct and foreign respondents, and thus what legal test applies to the jurisdictional issues posed by a complaint involving foreign entities' conduct outside South Africa. Now, that is the Commission's first ground of appeal in its application for leave to appeal, and the principal basis on which it contends it would be in the interest of justice for it to be granted leave to appeal. And the Commission's arguments on that issue also enjoy primacy in its written submissions, comprising the first substantive submissions taking up 13 pages. But as the BOA respondents pointed out in opposition to the Commission's application for leave to appeal, as well as in opposition to the Commission's application for leave to file a replying affidavit in that application, those jurisdictional questions were not, however, decided or argued in CAC 2, nor in the Competition Tribunal proceedings which preceded that appeal, CT2. This is because they had been comprehensively debated and finally decided in the earlier CAC proceedings of 2019-20, as well as in the earlier iterations of the Commission's referral at CAC 1, and after it being extensively debated in the initial tribunal hearing in 2018 and addressed comprehensively in the first tribunal judgment of June 2019, CT1. Now, contrary to what the Commission has suggested, CAC 2 merely involved an assessment of whether, in the light of the legal principles set out in CAC 1, read with the applicable procedural rules, the Commission's replacement referral affidavit of June 2020 sufficed to make out a case for the respondent banks to answer. And accordingly, any potential appeal from CAC 2 could merely pertain to that much narrower issue, and thus effectively a case-specific and factual or essentially factual question of the kind that has typically not been considered to engage the jurisdiction of this court or warrant consideration by the court in the interest of justice. Now, the Commission has incorrectly submitted that the BOE respondents objected to the Commission's raising of legal jurisdictional issues in its application for leave because they were not raised in the CAC. But that is not our argument. The main objection of the BOA respondents is that legal questions regarding the tribunal's jurisdiction over foreign conduct and foreign entities were not the subject of COC 2. They were, as mentioned, dispositively addressed in CAC 1. And had the Commission wanted to take issue with the CAC's findings on jurisdiction in CAC 1, as it now evidently wants to do, it should therefore have taken CAC 1 on appeal. But not only did the Commission not do so, it signalled its acceptance of that order by seeking to comply with the CAC 1 order in its replacement referral affidavit of June 2020. And my learned friend for the Commission has reiterated today that they are not seeking to appeal CAC 1. The Commission is therefore precluded by the principles of res judicata and issue estoppel from seeking to revisit the jurisdictional issues finally decided between the Commission and the respondent banks in CAC 1. Now, on the BOA respondents' heads, the objection to the Commission's attempt to revisit jurisdictional issues in its appeal from CAC 2 is motivated inter alia with reference to a High Court judgment in which it was held that a party to an action in which there's been a separation of issues cannot, during the second round of the matter, seek to amend the case that it presented in the first round, and thus revisit issues which were finally determined in an earlier judgment which had laid the basis for the second leg of the action. One could also take the analogy drawn from actions with separated issues further. If, for example, there's a separation of merits and quantum, with the merits determination itself susceptible to appeal, delineating what would needed to be proved in the quantum inquiry, a plaintiff who accepted the outcome of the merits hearing and thus the merits order and then ran the quantum hearing on that basis could not, in appeal against the order made at the end of the quantum hearing, seek to argue that the merits order was wrong and that its quantum evidence would at least have sufficed had the merits leg been decided differently. And the plaintiff in that scenario could certainly not seek to make such an argument in an application for leave to appeal against only the quantum judgment and order, and thus in an application for leave to appeal which was not also directed against the merits order. Now, in the present case, the arguments the Commission now seeks to advance in respect of jurisdiction were to all intents and purposes the same as those which were raised in CAC 1, and this can be neatly seen from the summary of the Commission's appeal, or more accurately, cross-appeal in CAC 1, which is on page 12 of the CAC 1 judgment, page 91 of the record. In the light of the findings in CAC 1, the Commission did not make submissions in CT2 or CAC 2 about what jurisdictional test applied to referrals involving economic activity outside South Africa by foreign actors, or thus to the meaning and effect of Section 3.1 of the Competition Act, and nor would it have been allowed to do so, as any such attempt would doubtless have been met with an objection from the tribunal or the court that this had been finally disposed of in CAC 1. Now, the Commission appears to accept that its written argument in CAC 2, as well as its argument in chief in CAC 2, did not indeed make such arguments, but it asserts, with reference to an excerpt from the CAC 2 transcript that it sought leave to adduce in a replying affidavit its application for leave, that a jurisdictional issue was raised by the lead counsel in argument in reply, and that's at 649 and following of the transcript. And what's interesting about that transcript, it's difficult to follow, but at a couple of occasions, President Davis said, but we dealt with that last time, and my learned friend acknowledged that was the case. Now, the BAA respondents, when opposing the application to introduce that transcript portion, contended that the Commission misrepresented the gist of its oral argument, and we stand by that. But they have also, in any event, demonstrated the opposing affidavit with reference to excerpts from the Commission's heads in CAC 2, that as one would have expected, the Commission sought to comply with the CAC's jurisdictional findings and orders in CAC 2 in their written argument, an argument in chief, rather than to challenge them. Had the Commission wanted to advance before this Court the arguments that it is now set out in Section 2, pages 6 to 18 of its main heads of argument, it should therefore have sought to appeal the relevant orders in CAC 1, but it has never done so, either after receipt of CAC 1 at the end of February 20, or when seeking leave to appeal CAC 2 in February 2024, and it confirms again today that it does not intend to seek such leave. The Commission sought to justify its failure to appeal CAC 1 on the basis that it was substantially successful in that appeal, and there was consequently nothing that it could allegedly appeal, but that is clearly wrong. The orders in paragraphs 3.2.1 and 3.3.1, which dealt with the CAC's findings on subject matter and personal jurisdiction, could plainly have been appealed by the Commission had it been desirous of doing so. The reality was the Commission was prepared to be bound by those orders in keeping with the res judicata and issue estoppel principles, and to attempt to comply with them as it evidently thought it could do. The Commission cannot now attempt to reverse course and advance the kind of arguments which would have been competent in an appeal against CAC 1 in the context of an appeal against CAC 2. It has thus submitted the Commission's first ground of appeal in its application for leave to appeal to this court, as well as the arguments advanced in Section 2 of its main submissions cannot competently be advanced. That also in turn means that the key prongs of the Commission's argument in Section 6 of its main heads of argument as to why leave to appeal should be granted would be inapplicable. Now, the Commission's submissions regarding jurisdiction are in any event unsustainable. The Commission submits that 3.1 of the Competition Act supposedly involves an unqualified effect test, or in other words, that economic activity outside South Africa, which has any effect within the country, would be caught by the Competition Act. The Commission submits too that Section 3.1 purportedly allows the competition authorities to proceed against any person or entity responsible for economic activity which has an effect within South Africa, irrespective of where they are based, and thus contrary to the long-established test under the common law. And they say that, contrary to the long-established test under common law, there's no longer requiring of personal jurisdiction in competition matters. Now, as we submitted in the BOA respondents' heads, this would result in South African competition authorities having unparalleled worldwide jurisdiction, and would, for example, mean that the Commission and the Tribunal would have jurisdiction over two foreigners colluding in, say, Alaska over the price of South African apples. And it would also likely result in the competition authorities being overwhelmed with cases involving foreign contracts with which a party is desirous of not complying, with little impact on South Africa. And it would also run contrary to the well-established principle of effectiveness. Now, if the jurisdictional debates settled in CAC 1 were held to be capable of being re-argued in an appeal from CAC 2, the Commission's approach should thus anyway be rejected. And there's not time in this opening to revisit the contentions made in CAC 1 or the basis for the determinations made by the Tribunal and CAC on these issues back in 2019 and 2020, and other respondents might anyway do so. But I'd like to mention a few factors which we submit show that the Commission's argument is unsustainable. First, Section 3.1 only purports to deal with subject matter jurisdiction. It does not address personal jurisdiction at all. For the Commission's interpretation to be upheld, it would therefore have to be found that the section impliedly repeals the common law. That would either be contrary to one of the most fundamental presumptions of statutory interpretation, namely that a statute should be read in conformity with the common law unless it clearly or by necessary implication indicates otherwise. And relatedly, the argument by the Commission that the common law is somehow not applicable in competition acts by virtue of the Competition Act is also plainly wrong, as we've submitted in our heads. And finally, I note the concession that my learned friend, or the submission that my learned friend made in response to Justice Colopin's comment that the same provision is found in the NCA must in any event be destructive of their case, because the same clause, a section in the NCA clearly doesn't ask personal jurisdiction. So if it's going to be interpreted in the same way in both statutes, it can't ask personal jurisdiction in the Competition Act either. Now, secondly, doing away with personal jurisdiction would also result in various anomalies, inconsistencies vis-à-vis the Competition Act, not least because, one, an order of the Tribunal, including an administrative penalty from the Tribunal, can be enforced as if it were an order of the High Court, Section 64. And there must therefore be an equivalence between the two, in other words, Tribunal orders and High Court orders, insofar as personal jurisdictional reach is concerned. And secondly, the CAC is a court with similar status to a High Court, and would not thus lightly be assumed to have jurisdiction over persons who would not be defendants or respondents in High Court proceedings. And there are also other indications in the Competition Act that complaints and complaint referrals were not envisaged against foreigners with no business presence in South Africa. For example, subpoenas cannot be enforced against them, administrative penalties cannot be imposed on them because they have no turnover in South Africa. So the same test used for assessing personal jurisdiction in the High Court which, as the CAC noted in CAC 1, has evolved to include a consideration of adequate connecting factors should apply in competition matters. And thirdly, as for subject matter jurisdiction, an unqualified effects test, i.e. an interpretation in terms of which all economic activity having an effect of any kind in South Africa would be covered by the Competition Act, would cause South African competition law to be out of step with Europe and North America, as well as in conflict with international law principles regarding appropriate legal forums, and moreover likely to result in the competition authorities being overburdened with cases with little impact on South Africa. And the Commission is also incorrect when it contends that the ANSAC case laid down an unqualified effects test. The CAC and SCA were concerned with a different issue in that case, whether it needed to have an adverse effect, while the CAC referred with approval to other jurisdictions where the effect must be direct and substantial. So as already noted, what CAC 2 was actually about was about whether the Commission's referral affidavit of June 2020 complied with the prescripts of the detailed order in CAC 1 and other applicable procedural rules. In other words, the issue in CAC 2 was whether the June 2020 referral affidavit made out a case for personal jurisdiction in respect to the foreign peregrini with reference to an adequate connecting factors test, and subject matter jurisdiction in respect of all foreign peregrini with reference to a qualified effects test requiring an immediate and substantial effect which was foreseeable, as well as whether the Commission had adequately pleaded a case regarding a single overarching conspiracy, SOC, against all of the bank respondents. Now, the Commission contends the CAC erred when conducting that inquiry, which was largely an auditing exercise with reference to paragraphs of the order in CAC 1, because it failed supposedly to have regard to what was required under Tribunal Rule 15.2. But the Commission was wrong in that regard. The various pleading prescripts in the CAC 1 order reflected the CAC's judgment as to what Rule 15.2 required the Commission to plead for a case of an SOC against the various foreign and local bank respondents. And if the Commission did not agree with the CAC's findings and the resultant precepts, it should have taken the relevant paragraphs of the CAC 1 order on appeal, but it did not do so, instead being content to comply therewith. Now, the CAC's conclusions regarding the adequacy or otherwise of the Commission's pleaded case in the June 2020 complaint referral are party-specific. It held the Commission's allegations in respect of some bank respondents sufficed, but didn't suffice in respect of the majority. And I'll therefore address that issue with reference to the case made out against the 3 Bank of America respondents, all of whom must be assessed individually in respect to the allegations against them. But before performing that exercise, it's important to make 3 preliminary observations. First, the BOA respondents comprise 1 respondent, Bamley the first respondent, and 2 parties referred to as purported respondents, as they are not yet respondents, but rather parties whom the Commission desires to join as further respondents, MLPFS, the 20th respondent, and BANA, the 21st respondent. Second, the inquiry in relation to those 2 categories of respondents is different. As Bamley is already a party, the question is whether Bamley can succeed in getting out of the case by means of an exception. By contrast, because MLPFS and BANA are not yet parties, the question is whether the Commission can show that they should be brought into the case by virtue of being joined as additional respondents. And third, and relatedly, the test in respect of those categories of respondents is also different. Firstly, the test in relation to Bamley is the usual test in exceptions, and thus involves a consideration of whether the facts alleged by the Commission in its replacement referral suffice to show both the Commissioner's jurisdiction over Bamley, a foreign peregrinus, a pure foreign peregrinus, and that Bamley is prima facie implicated in the SOC alleged by the Commission. As the CAC observed in CAC 1, there's some overlap between those aspects, because if the Commission pleaded a non-acceptable case about Bamley's involvement in an SOC involving South African banks designed to affect the ZAR, then there would likely be sufficient connecting factors to justify personal jurisdiction against Bamley, foreign peregrinus, and there would also be likely to be sufficient allegations to satisfy a qualified effects test and thus make out a subject matter jurisdiction. The test with regard to MLPFS and BANA, on the other hand, is the usual test applicable to joinder applications. One is thus not confined merely to what the Commission has alleged, but can instead look at what the potential or purported respondents have put up in answer, and what, if anything, the Commission has stated in reply thereto. Further facts can therefore be considered in that context, and regard can also be had to factual issues that are common cause. The Commission has confused the different inquiries and tests with regard to the B3 BOA respondents and also misrepresented the position applicable to them and what has been asserted on their behalf in particular. Now, the Commission contends that BAMLI, MLPVS and BANA brought what were effectively dismissal applications, but they did not. BAMLI instead brought an exception, albeit using the form the tribunal appeared to sanction for exceptions, presumably in light of Tribunal Rule 42, and that cast just arguments and affidavits. The directives of the tribunal show that they regarded exception applications as the way to proceed. And MLPVS and BANA opposed joinder applications brought by the Commission in which they exchanged affidavits with the Commission in response to the Commission's founding affidavit. Now, the Commission furthermore alleges that the BOE respondents impermissibly sought to add facts in an exception, but that misrepresents the case presented on exception. BAMLI's exception was argued with reference to facts put up by the Commission, but what BAMLI did also assert was that the Commission and the Tribunal and the CAC could not sensibly ignore facts which were not disputed in the joinder application and were in fact used against other BOA entities in that context when adjudicating the exception application of BAMLI. Now, the Commission contends too that the reliance on common cause facts in the joinder application was somewhat impermissible, and indeed a stratagem to introduce selective new facts through the back door pre-pleading. But there's obviously no merit in that contention. It was clearly competent for MLPVS and BANA to rely on the full conspectus of facts in their joinder applications to resist their joinder. Now, before proceeding to consider the cases the Commission has made out against the 3OB respondents, which I have 10 minutes, it's also appropriate to note there appears to be agreement between the Commission and the bank respondents regarding the requirements for the existence of an SOC, which in line with European jurisprudence such as team relocations, as well as a US case law, and was held by the Tribunal in CT1 to involve three requirements. First, the party alleging the SOC had to show, one, the existence of an overall plan pursuing a common objective or identical purpose, two, the intentional contribution by that firm to that plan, and three, and this is important, the awareness, proved or presumed, of the offending conduct of the other participants. Now, it's convenient first to deal with BANA, the 21st respondent. The tribunal joined BANA in CT2 essentially on the basis that Section 59(3)(a) of the Competition Act purportedly allowed a holding company to be liable for the actions of a subsidiary, but the Commission obviously does not, understandably does not seek to defend that wrong finding, which was overturned by the CAC and CAT2. But the Commission argues that unlike the other holding companies against which it no longer proceeds in the light of its abandoned reliance on Section 59(3)(a), BANA should still be joined because it may have employed one of the two traders, Cook or Shepherd, who is said to have acted on behalf of a BOA entity. Now, the Commission groups BANA together with respondents such as JP Morgan and SBSA in its heads of argument and argues in this regard that BANA, like those respondents, could not seek to introduce new facts to get out of the referral before pleading over. But that is an obviously bad argument because the other two entities referred to are respondents seeking to escape the referral by way of exception. By contrast, BANA, as mentioned, was a purported respondent whom the Commission is seeking to join as a further respondent. So unlike in the case of the other respondents to the original referral, regard can obviously be had to the affidavits and evidence in the joinder application. Now, the Commission alleged in its founding affidavit in support of the joinder of MLPVS and BANA that BANA could have employed Cook. It didn't mention Shepherd until June 2020, and the Commission's mention of him can anyway be disregarded, as I shall explain briefly below. Now, the first answering affidavit of MLPVS and BANA in opposition to the joinder stated unequivocally and clearly that Cook was employed at all material times by MLPFS and only represented MLPFS. It was also observed the Commission never bothered to contact any BOA entity or the BOA respondents' attorneys to seek to establish which company could potentially be implicated by Cook's actions. The Commission, in reply, referred to and attached the BOA respondents' attorneys under oath. Now, the relevant parts of the affidavit, it's 1190 and following is the Commission's reply, and 1277 and following is the BOA respondents' answering affidavit in the joinder. So the Commission acknowledged that, attached the affidavit of Sean van der Meulen, but did not provide any controverting facts or any serious basis for challenging those sworn statements. It's thus effectively undisputed in the joinder application that Cook was not employed by BANA, but instead by MLPFS. It's also clear the Commission has no facts evidencing or even suggesting the contrary. Now, the high watermark of the Commission's case is that Cook signed into the Old Gits chat room at various times with an email address ending at baml.com or at ml.com. The Commission states that it therefore infers, that's its words, that Cook was employed by BAMLI and or MLPFS and or Banner, and that thus one of 7 possible employment options existed. But that inference is not a remotely reasonable one, let alone consistent with all the pleaded facts. It was instead uninformed conjecture. Neither of these email addresses suggested Cook was employed by Banner, a North Carolina company, nor, contrary to what the tribunal erroneously stated in C2, is Banner the holding company of MLPFS. It is instead a company in a different branch of the Bank of America Group entirely. Not only is there no reason to infer that Cook was employed by Banner, there's also no basis to suspect that the BAA Group would later seek to suggest that its attorney statements under oath about Cook's employer were incorrect. Now, the Commission suggests today that they're relying on authorization, but that has never been raised before, it's never been pleaded, and with respect, it's contrary. It's also not supported by an inference. Basically, what the Commission was saying in their referral, they were trying to catch the person under any company, saying you employed, you authorized, you represented. It is quite clear that he was employed and represented MLPFS, and that has not been contradicted. Now, the positions of BAMLI and MLPFS can be dealt with together, albeit that one's a respondent, one's a purported respondent, both are pure peregrini. Now, as a bank can only be implicated in SSE through a trader, the starting point of the inquiry must be an examination of the allegations made in respect of the traders whom it's alleged traded on behalf of BAMLI and MLPFS, namely Cook and Shepherd, and that inquiry must also be conducted with reference to the facts that the CAC said must be pleaded in CAC 1. For example, the fact that if you're relying on inference, you must give the material facts on which you rely, and you must also plead adequate connecting factors, etc. Now, almost nothing is averred about Shepherd. He was mentioned for the first time in the June 2020 replacement affidavit and was then only referred to 3 times. All that is mentioned about him is he's supposedly an employee of BAMLI and or MLPFS or Banner, which is an inference they say, and that he's a member of the Old Gits chat room. Now, these various mutually inconsistent allegations about his supposed employer are by the Commission's own admission an inference. There's no factual basis for the inference. There's, for example, no allegation of where Shepherd traded, what login email he used to enter the Old Gits chat room, if he ever did. It's not known if he had any contact with any other named traders, or if he did log into the Old Gits chat room, who was there at the time or what was discussed. The Commission has therefore not pleaded facts about Shepherd which could be relied upon to show that BAMLI and or MLPFS joined the SOC, or that there are adequate connecting factors between either of them and the jurisdiction tribunal, and it's not provided sufficient basis for the inferences to be drawn. And it should also be noted that the Old Gits chat room, it's alleged the Old Gits chat room did not serve any legitimate purpose. As the tribunal remarked in CT1, that omission is important, for if the chat room existed solely to further the conspiracy, one might understand an argument that you could not realistically join it for benign purposes. But if it could be used for both benign and malign purposes, simply joining it wouldn't result in an inference. Another consideration, as the Commission also noted in that context, is whether a chat room is specific to rand-dollar trades. For if other currencies were also traded, as the initiation statement suggests at record 483 and 490, the notion that joining the chat room to further the ZAR USD conspiracy is further undermined. And in addition, it's been held in USA exchanging information about trading prices is not necessarily unlawful, to some extent necessary in forex trading. So we should respectfully submit nothing can be drawn from the allegations about Shepherd, and BAMLI and MLPFS cannot be brought into the case on that basis. Therefore, the case depends on Cook. Now, this must be considered with the reference to the fact it's essentially common cause in the joinder application that Cook was at all material times employed by MLPFS and represented MLPFS. We submit it would not be sensible or practical, according to the interests of justice, or consistent with the standards expected of the Commission as a public body, to proceed on that basis when joining MLPFS, and yet ignore that fact when considering the position of BAMLA for purpose of the exception. This is more particularly because the Commission has not alleged as a fact in its replacement referral affidavit that Cook was employed by BAMLI. Instead, it, as mentioned, alleges 7 mutually inconsistent alternatives involving his login name, BAML or ML.com, and they cannot reasonably lead to an inference that the position has been misrepresented under oath by the Bank of America's attorney. In any event, the allegations regarding Cook are inadequate to make out a case that he is involved in the SOC contended for by the Commission, and more particularly in SOC with South African banks, which had as its purpose the manipulation and distortion of normal competitive conditions in the trading of the USD ZAR currency pair. Now, the Commission prepared various diagrams which are attached to the CT2 decision. The first diagram, Annex B, shows the chats or other communications between the respondent banks. The second shows trades between local banks or local banks and foreign banks. And the third one, if they try to combine the two, is an intermeshing of the both. But these diagrams and the allegations in the June 2020 replacement furlough on which they were based do not make out a case that Cook, or thus Cook's employer, was part of an SOC involving South African banks. Cook is not alleged to be involved in any of the trades involving local banks mentioned by the Commission, so no BOA company is mentioned in the second diagram. Cook is not alleged to be involved in any chats with any South African bank, and there are therefore no lies between the BOA block in the second diagram and SA Bank. And thirdly, no South African bank's representative is alleged to be a member of the old GITS chat room of which Cook was a member. So Cook was a member of the old GITS chat room which just had foreigners, and he never spoke to any South African or was involved in a trade with any South African. The case then is based on involvement in the old GITS chat room, but as we point out, old GITS chat rooms not alleged to be set up for nefarious purposes or only for the ZAR USD trading. Cook was not a member of the ZAR chat room, which one can assume had a ZAR focus, and therefore we submit insufficient allegations to infer that Cook intended to join an SOC involving South African banks. Now, the Commission argues that the CAC implied the wrong test by looking at whether there were any links between Cook and an SA bank, rather than considering whether there was a link between Cook's employer and the SOC, which involved SA banks. But that does not accurately reflect the CAC's approach. The CAC held there was no reasonable basis for inferring a link between Cook's employer and any SA bank, or thus a link between Cook's employer and an SOC with a South African bank. And that is dispositive because it will be recalled that the third requirement for an SOC is that a participant must have been aware or could reasonably have been aware of the offending conduct of the other participants and thus the nature and scope of the SOC. It was therefore necessary for Cook's employer to have sufficient to know or have sufficient information to know. Can I finish the paragraph or the sentence? The sentence, okay, it'd be a long sentence. Let me get my sentence. It's sufficient, so it's necessary for Cook's employer to know or have sufficient information that it could know of the actions, intentions of the various banks, and also have actual or deemed knowledge of the other foreign banks which are not in the old GITS chat room with which Cook did not interact, something which, of course, Thank you very much. Thank you.